commencing this series of workshops called Perspectives on Insolvency Bankruptcy Code. And today is the first in the series focused on a topic which is slightly outside insolvency law, because we're not even talking about insolvency here. When we talk about voluntary liquidation, we're talking about someone who is not insolvent. So provisions pertaining to voluntary liquidation, which is essentially pertaining to a company which is not insolvent, therefore by definition a solvent company, and that too being housed or stationed in insolvency bankruptcy code. The only region for this locating or placing the provisions pertaining to solvent companies in IBC was to take advantage of the new law. As I'm sure you would all appreciate that one of the major objectives of the new law, when I say new law, we're talking about 2016 IBC, was to provide for or facilitate the ease of exit. And when you talk about ease of exit, exit would come in two ways. Either you are forced to exit, you're no more viable, you are insolvent, your business is not working well, there's no chance of repair or resurrection of the business, and therefore you are forced to exit. That's a forced exit, which happens in case of insolvent companies. Insolvent companies either pass through a process of resurrection, they get resolved by way of in CRP process, or they go through a forced liquidation. Other option is the company is solvent and still doesn't want to carry its business further for a variety of reasons. The company's business model is no more relevant. The company was formed, but the business never started. Or for whatever reason, the company doesn't want to continue its existence, and therefore the company has to be put into a terminal phase of liquidating its business. So voluntary liquidation. There's nothing called voluntary insolvency. When you talk about voluntary liquidation, we're talking about voluntary liquidation of a solvent company. Now, our objective today, and like Prashla mentioned, the workshop would be partly taken by my colleague Barsha Dixit, who's already here today. She'll deal with the procedural, practical technicalities of voluntary liquidation. I'll start with why voluntary liquidation. I'll start with basically the rationale for voluntary liquidation, what circumstances voluntary liquidation is appropriate. I would also compare other ways of what you call pulling the shutters on the company. Essential objective is we want to pull the shutters on the company. We want to close the company. What are the various ways of closing a company? Is voluntary liquidation the only way? And if there are other ways by which a company can be terminated, then how does voluntary liquidation compare with those other ways? Now, we will start with first understanding of what are the circumstances in which voluntary liquidation works. And let me just start with okay, there we are, and we'll talk about various modes of corporate exit. Like I said, ease of doing business includes ease of exit as well. All professionals who have gathered here, large number of people already are there. I can see some 50 people already have entered. I'm guessing that more might be entering as we go. Now, I'm sure all of you are looking forward to interaction. I am definitely looking forward to interaction. So I would love to interact with all of you. However, my request is that the messages which are constantly coming on chat board, which is basically your registration number, I believe you can share the registration numbers with ICSI, IPS separately for CP hours or whatever the purpose it serves. As far as interaction with me and my colleague Barsha is concerned, I would suggest keep it with yourself. We will have intermittent, time slots where we'll carry out this interaction. I would request you all to maybe hold your questions and comments until then, instead of putting your questions on chat board, because it might be difficult for us to scroll up and search your questions and adequately deal with it. Questions, comments, reactions, feedback, whatever, please feel free, do as much as you would. I definitely look forward to that. I think I'm benefited tremendously by the interaction, but we would like to maybe make a little advancement in our delivery, and then look forward to having Q&As with you all. So when I talk about various modes of exit, I just mentioned that ease of doing business, which is a theme that regulators all over the world currently seem to be pursuing. India also was pursuing that. World Bank had a certain, ease of doing business report, but that report stopped for a variety of for reasons that all of you, I think, might be aware of. But nevertheless, ease of doing business also includes ease of exit. Unlike natural beings, which have a definitive life, defined, undefined, whatever, whichever life. In case of corporate existence, it is deemed to continue until liquidated. As we say, company is a creature of statute. It can be terminated only by the statute. It continues to live on until it is liquidated in accordance with the provisions of the statute. Perpetual succession. None of us have perpetual succession. Our lease of life is quite limited when it comes to companies. If you create a company, we have created it for all time to come, unless there is a process of terminating the company. And like we understand, quite often it might be necessary to terminate a company because there might be pool of funds, there might be pool of assets, there might be pool of liabilities, there might be resources, and we might like to upstream those resources to the shareholders, and therefore we might need to terminate the company. So what are the various modes of corporate exit? Well, under the Companies Act, striking off of a company in terms of Section 248, voluntary striking off. As I'm sure you understand, striking off can happen only, striking off may also happen by the registrar. Registrar may strike off a company which is defunct. The moment we talk about striking off, we are necessarily talking about a defunct. Defunct companies are struck off. Defunct meaning the company has become defunct. It's as useless as a useless piece of paper. It can just be rubbished and put in the trash can. So striking off is like putting the company into a trash can. There's no asset, no liability, nothing in the company. Either the registrar thinks the company is not working, it stops its business, it stopped filing financial statements, it's failed to commence business for a certain number of years or whatever. Those are circumstances where the registrar of companies may strike off the name of the company. But Section 248 also envisages the company itself voluntarily proceeding for an action of striking off. However, the precondition for that striking off is that precondition for striking off, because you cannot strike off the name of a functional company. The company must be defunct. That means it must have stopped functions. It must not be carrying a significant accounting transaction. And at the same time, the company must have what you call nil assets and nil liabilities. Technically, no company will ever have a situation of zero assets and zero liabilities. Nil meaning almost nil. There's nothing to distribute, nothing to pay off. Whatever assets were there have been realized. Whatever liabilities were there have been paid off. There is now nothing left in the... When we come to a situation of nothing left in the company, nothing left, dabba khali hai, kuch nahi, that's when we can think of throwing the company out of the window. And that process of throwing the company out of the window is called striking off. Please never think of striking off resulting into a payment to shareholders, because the very premise of striking off is that there is nothing to pay. Nothing is there in the company. There's no question of any payment. Hence, striking off of a company means we are simply trashing something which has become completely empty, something which is completely void. So that's the first way. And I would say among the ways, that's perhaps the easiest way. Because in terms of time taken, in terms of procedural simplicity, we don't need an insolvency practitioner there. We don't need an NCLT there. We don't need anything. We just make an application to register in a particular whatever form, STK, whatever, and there is a publication in newspaper, etc. If the company doesn't get any objection to strike off action, we just have the company struck off. So struck off is like फाड़ के फेंकना, नाम को काट दे, company के नाम को strike off कर देना. ROC will strike off the name of the company from its registry on the ground that the companies virtually cease to exist. That's the meaning of striking off action. We may not want to strike off a company. The company might have become defunct. but we may still like to retain the corporate existence for something in future. In that case, we can put this company in a state of dormancy, dormant company. Dormant company is actually not a mode of liquidation. It's not a mode of exit, because the dormant company at some stage will have to be revived. So dormancy meaning there are no regular functions, and therefore filing burden or burden of calling board meetings or general meetings, etc., may be minimized by achieving a dormant. It's not actually a mode of exit, but let's say state of hibernation. We are not putting the company into a state of death. We are not giving the company into a morgue or into a crematorium. We are taking the company to a hibernation where the company will lie in the cold storage for years until we think of reviving the dormancy status. Please understand that practically one of the very common ways of ending corporate existence is merger. That's, I would say, between voluntary liquidation and merger. I would say mergers are far more common than voluntary liquidation. And that's it, actually regrettable. It's a matter of regret. I don't see why voluntary liquidation should not be as efficient or more efficient than a process of merger. Merger, actually, there are two entities involved. In voluntary liquidation, we have only one entity. Merger, there might be two or more. Sometimes there are mergers of large number of entities. A lot of entities in question. And therefore, that process ought to be far more detailed, far more complicated exchange ratios, etc., being there. But when it comes to voluntary liquidation, it ought to be a very simple process. But unfortunately, the way the process is currently working, or so far working, it is still prone to NCLT or adjudicate authority route. And that is where it takes a long time. I think those of you who have experience of running voluntary liquidation probably say, well, it is supposed to be fast, but where is it fast? Because the moment you file an application to adjudicate authorities, you never know when will your turn come before. I think we shouldn't be lamenting about what is happening in NCLTs, but well, we understand that the process may take a long time. I think what I should have done is to ask you, I can see some 54, 55 people already participating here. Can I just quickly ask you a question? How many of you, if you can help me by raising your hand, please don't type in the chat, maybe do a hand raise. I hope that's possible. So can you raise your hands and say if you are currently undergoing or currently handling some voluntary liquidation? Can participants please raise hands too? I can see one hand going up, others. Can you please help me indicate how many of you, if you can raise your hand and say how many of you are currently handling voluntary liquidation? Okay, I can now see 4 hands have gone up. Is that all? 4 people in the audience, or these 4, professionals who raise their hands, if you can kindly lower your hands now, or maybe I can lower them now. And please also help me now to say, if you can also now raise your hands and let me know if you are potentially going to handle a voluntary liquidation. Are you like potentially going to handle, that is, are you looking at a potential client where you'll be handling voluntary liquidation? I can see 1 hand is gone up, 2. Well, some of these are common because the people who are actually handling are also those who are potentially handling. 4 hands have gone up now. Okay. In fact, yeah, several. Good. So that makes it interesting, because then there are people who really have immediate interest in the subject, and that's very exciting. So I was saying the process ought to have been much faster, but as of now, the experience is that it's not as fast as it ought to have been. Possibly the code is also likely to undergo some kind of amendment to make it simpler. But I was saying, between mergers and voluntary liquidation, merger also puts an end to the corporate existence. If there's a company A, company B, and company B is merging into company A, B gets out of existence. So B is merged. and therefore it's dissolved without winding up. We call it dissolution without winding up. B is dissolved without winding up, and B gets merged into A. All the assets and all liabilities get shifted to A, and the corporate existence of B is dissolved without winding up. So that's also a way to put an end to the existence of the company. But we need to compare. There are situations where merger works. There are situations where merger doesn't work. Merger works when you're actually wanting to shift assets and liabilities to a company which is operating. Mostly it happens when there is a holding entity or entity holding significant interest, which is where you want to shift the assets and liabilities. If the objective of the client or the objective of the entity is to distribute the proceeds of assets to shareholders, or say the shareholders are not bodies corporate but individuals, the question of a merger would not arise if shareholders are individuals. Who do you merge the entity in? If the ultimate objective is to distribute the proceeds to individual shareholders, merger never works. Merger has advantages over voluntary liquidation because merger is a tax neutral transfer. Voluntary liquidation surely is not tax neutral. It's far from being tax neutral. It's not tax neutral at all. Mergers are tax neutral. Therefore, one needs to take a very calculated call on what works better. Voluntary liquidation will work better, or merger. Sometimes it might even be that a going concern is actually merged through the process of merger, and the remaining entity may be actually taken for voluntary liquidation. So it might also be a combination of a merger and voluntary liquidation. So where I would be focusing, and I would be maybe spending quite some time discussing this, is that we need not take voluntary liquidation as given. Madan Gopalji, if you can kindly mute yourself. We need not take voluntary liquidation as a given. Clients quite often, may I request Madan Gopalji to please mute himself. Madan Gopal Jindalji. So I was saying, we need not take voluntary liquidation as given. Clients may quite often not have made a clear choice for themselves. They might be looking at your advice. They might be expecting you to advise what works better. Voluntary liquidation works better, merger works better, or whether striking off is possible under circumstances. So please feel free to do a circumspection and find which process of corporate exit works well in the given circumstance. So merger versus a voluntary liquidation is something that we will be discussing, of course. There's also a certain section called summary liquidation. There's also 361 of Companies Act. Under the Companies Act, if the assets are having a nominal value up to ₹1 crore, in that case, we don't need to follow the process of section 271. There is so-called summary liquidation process where the official liquidator will be the liquidator and will liquidate the company. Though this process has been there from 2020, to best of my understanding, there's hardly any taker of this process. And this process runs to OL's office, and OL office, I think if past experiences of any indicator, well, I think one doesn't know how long will the process work. So I don't think this is actually, it's a provision in the law, but how many takers does it have? I wouldn't have known. Liquidation under section 33, this is involuntary liquidation. It's not voluntary, involuntary, forced. The company was under CIRP, the CIRP did not proceed, or the resolution plan was not acted upon, and therefore the company has been forced into liquidation in terms of section 33. That's not a subject matter today. We will rather be discussing voluntary liquidation in terms of section 59. So we'll be very quickly moving to that. Let me first once again very quickly deal with this various options. So as voluntary liquidation in terms of, in case of a default, that is involuntary liquidation, which happens in case of a default. Defaulter who has committed a default either in meeting a financial obligation or operational obligation and is taken into insolvency first and thereafter liquidation, that's a case of involuntary or compulsory liquidation under IBC process. That's not our subject matter today. We will be discussing briefly, of course, section 271, because 271 equivalent of section 424, 425 of the 56 Act. That's the process under Companies Act. With the promulgation of IBC, the Companies Act has become very or has been reduced to very little practical relevance, because most of the situations are either covered by section 59 of IBC or are covered by section whatever, I mean, CRP process of the IBC in Insolvency Bankruptcy Code. So the relevance of section 271 is hardly there now, except in cases where the substratum of the company is gone, the just and equitable clause is applicable, or the company was a limited life, limited purpose company, or the shareholders have passed a resolution to be wound up under the supervision of the court, supervision of the NCLT. If the shareholders have resolved that they are desirous of being wound up under supervision of the tribunal, in which case probably the tribunal will select a liquidator who may or may not be in IP. It might, who knows, it might be even the OL's office. So that's a very rare situation where section 271 comes, except in case of financial companies, because as you understand, financial companies are currently excluded from IBC. It's a little travesty of the law. I think it was not intended that way, but it's come to be understood that way, probably because of some rulings of NCLT, which has perhaps taken that every NBFC is a financial services provider, though that's not a correct ruling in my view. My most humble view is that that's not a correct understanding of the law, but somehow the feeling is that IBC is not applicable to NBFCs or banks for that matter. And therefore, in that case, IBC is not applicable. So if IBC is not applicable, section 59 is also not applicable. And therefore, voluntary liquidation of an NBFC cannot be done under IBC. It has to therefore go to section 271 only. But voluntary liquidation, which is a subject matter for our discussion today, can be done under section 59 of IBC, read with the voluntary liquidation regulations of 2017. Some of the other provisions of IBC, including section 35 to 53, both inclusive, are also mutatis mutandis applicable to voluntary liquidation as well. And we will have occasion to discuss what exactly are those provisions. I refer to section 361 summary liquidation. I said companies having assets of rupees 1 crore, fulfilling certain other conditions as well. They may be wound up under the so-called summary process, which is, we hardly know whether the summary is actually summary. Madan Gopalji, I request you kindly keep yourself muted. Otherwise, maybe ICSI can mute Mr. Madan Gopalji. Probably is not wanting to speak, just by error that his audio is coming up. Not a problem. So I was saying the so-called summary process, we don't have an experience of that. We don't know whether it actually works as summary process or it's actually belying the name summary. Winding up of unregistered companies is also possible. That is, companies which are, de facto partnership firms may also opt for winding up under the Companies Act. This was a long-standing provision of Companies Act. It was there in the 56 Act also, that courts could actually, at the option of the partnership firm, courts could be engaged to wind up a partnership firm as well, just to get the benefit of judicial supervision. Dissolution without winding up, which happens in terms of section 232, that is pursuant to a merger, the company is dissolved without winding up. No process of winding up there, because assets have anyway been shifted. All assets and all liabilities are gone. The company still remains as a corporate shell, and that corporate shell is wound up in terms of section 232(3)(d), which is dissolution without winding up. And then we talked about section 248, which is striking off the name of a defunct company. Now, I will not be spending much time on section 361, as that is anyway, we don't have a practical experience of how well it works, but I would want to compare particularly merger versus voluntary liquidation. Striking off is applicable in extremely, I would say, different situation where the company is actually raddi ka kagaz, like I mentioned earlier, no assets, no liabilities. So nil assets, nil liabilities, no accounting transaction over the last whatever period. And in such circumstances, the company may apply for striking off under section 248(2). That's, like I said, the precondition for that is that the company has become defunct. Company has become completely empty. The company is a, as you could say, once again, I'll say khali dabba. There's nothing in the company. It's a corporate shell with nothingness into it. I can simply strike the name of the company. Dormant companies works in different contexts. It's not our exact comparable. Merger versus voluntary liquidation. Now, in merger, what do we need? For the purpose of merger, we are thinking of a scheme of compromise or arrangement. Section 230 onwards will be applicable to a scheme of merger. So we are filing for a scheme. We are taking the sanction of creditors. We're taking the sanction of members. We are going through an NCLT process. And what happens in the merger is that the assets and liabilities of the transferor company may be vested in transferee company, with the transferee company issuing shares to the shareholders of the transferor. So transferor company goes out of existence. Shareholders get the shares of the transferee company. Once again, in case of a merger, there is very limited scope for a cash payout. Merger for cash is though possible, but possible only up to a limited percentage. Why? Because definition of merger for income tax purposes or definition of merger for accounting purposes both presuppose at least a certain percentage of the shareholders of the transferor company being issued shares of the transferee company. So payment of cash consideration in case of a merger so as to allow shareholders to cash out their holding, that has a very limited potential. That is very clearly, 100% cash out in case of voluntary liquidation, because every shareholder will get cash. But the question of a cash payment to shareholders in case of a merger is very limited. I'm once again emphasizing that one can actually, there are many schemes which issue preference shares to the shareholders of transferor company, and those preference shares may eventually be cashed out. But at least by process of merger itself, paying shareholders in cash, that has a very limited potential in case of a merger. So like I was saying earlier, if the objective of the companies is that the shareholders can be actually paid in cash. For example, if you talk about a foreign holding company which has a subsidiary in India, a foreign holding company had formed a subsidiary in India. The subsidiary is either not carrying business or has substantial assets, and the subsidiary now wants to distribute entire capital to the foreign holding company. If you choose to go for a merger, it would be a case of a cross-border merger. Cross-border mergers, I would say, are still possible. But since the law about cross-border mergers is evolving, this merger may be quite complicated. Instead, if you take the foreign subsidy, the subsidy of a foreign company into voluntary liquidation, you can at least start relegating the assets and sort of releasing them to the foreign holding company even before the voluntary liquidation is completed. So the advantage in voluntary liquidation is number one, cash out. Cash out to shareholders is not possible either in merger. No question of a cash out in case of striking off, because whole possibility of cash out is not even possible in striking off. In a merger, there's a very limited window for cashing out. In voluntary liquidation, it's entirely cash payment, of course, but you don't need to wait for the entire process to be completed. What you need to do, of course, is to serve notice to the income tax officer, wait for 3 months for the tax officer to allow, or the tax officer not to say anything, not to object to distribution. And then you can do an interim distribution. If you're sure that liabilities have been paid off, there is no further liability, you don't need to wait for final distribution. You can do an interim distribution. An interim distribution can take off, that is, release a large part of the distributable assets to shareholders even without waiting for the process to be completed. Completion of process is dependent on adjudicating authority's order. Given circumstances, that may be taking long time. Many cases 2, 3, 4 years. Applications are still pending for no reason though, except that, well, benches don't have time. But before that, a substantial distribution is still possible. So cash out to shareholders is possible in voluntary liquidation only. So that's prerequisite, of course, is that in case of merger, even solvency is not a precondition. Solvency is not a precondition in case of merger. Solvency is a precondition in case of solvency. The company must be solvent. The company must not have incurred a default. These are two important conditions. There are some further conditions as well. I'll be talking about those as I go. In case of a merger, liabilities of the transferor are shifted to the transfer. The entire undertaking, mostly the undertaking includes all assets and all liabilities. So liabilities get shifted to the transfer in case of a merger. there is no question of shifting liabilities in case of voluntary liquidation. In case of voluntary liquidation, as we're talking about a solvency, sufficiency of funds. So we use the funds to settle the liabilities, and then the remaining assets are released to the shareholders. So there is a question of liability of directors. The directors are signing on the dotted line in the declaration of solvency. So if it so turns out that what was believed to be solvent is actually not solvent, there's a deficit. In the meantime, we go on and distributed assets away to the shareholders. And now there are liabilities. We don't have money to pay the liabilities. Then the question of directors' liability would come. Because directors' liability for a wrong declaration of solvency, Section 72 of IBC provides for giving a wrong declaration of solvency. And there might also be a civil liability for a breach of fiduciary duty if the directors fail to recover the money which has wrongly gone away, despite the company not being solvent. The process is controlled by the liquidator. In case of voluntary liquidation, it's of course the liquidator. In case of a merger, well, it's controlled by the company itself. So that's also an important point. Once you pass the resolution for voluntary liquidation, the shareholders pass the resolution. Thereafter, the directors don't have any control over the company anymore. The control is ceded from directors to the IP. In case of a merger, even though we filed an application for merger, until the effective date, the entire proceedings will still be, the entire company will still be run by the directors. So the business continues. That's a very important point to understand. When do we choose voluntary liquidation? Can we do voluntary liquidation of a going concern? Can we do the voluntary liquidation of a going concern? Theoretically, I could say yes, because the moment the voluntary liquidation resolution is passed, the concern should stop to be going concern. But voluntary liquidation is definitely not an ideal process for a going concern liquidation. If the idea is to terminate the existence of a going concern, I would rather suggest merger, because the entire undertaking as such may bodily be shifted to the transferee. That's not possible in case of voluntary liquidation. I'm also not sure, and I don't think that actually should be appropriate, that going concern sale today in liquidation under IBC, compulsory liquidation under IBC, we have a process of sale as a going concern. I can transfer the going concern as it is. But can I do the same thing in voluntary liquidation? I would say, while it's possible to do what you call in-kind distribution, I can do a distribution in specie, in kind. I can do a distribution for sure. For example, properties of the company may be distributed in kind. There is nothing that forces me to liquidate the properties and then pay cash to share. That may be extremely inefficient. For example, if the company is sitting with properties, and let's say I have a single shareholder, I have only, let's say, two shareholders, single shareholder, for instance. Why do I sell the properties and give the money to shareholders? Shareholders may actually take the properties itself. So having settled the liabilities, if I have sufficient money to pay off the liabilities, and now I'm sitting with properties, the liquidator does not necessarily have to liquidate the assets and distribute cash. He may actually distribute the assets itself in specie. For example, the company has shares of another company. I can distribute the shares. So it's not that I have to necessarily sell the assets in a voluntary liquidation. I don't need to liquidate by selling. I can also liquidate by distributing in specie. But a going concern transfer, which happens in a compulsory liquidation, I don't see a possibility of that in voluntary liquidation. Process is, of course, the control gets shifted from the directors to the IP, because the moment you pass resolution for voluntary liquidation, the company by definition ceases to be a going concern. It now becomes what you call a concern waiting to be liquidated, because the process of winding up has begun. The process of winding up, meaning winding the affairs of the company up by sequentially selling of the assets, paying off liabilities, and releasing the money to the shareholders. Pay down to shareholders, we first need to settle the liabilities, then we release the surplus to the shareholders. Like I said, in case of merger, question of paying or cashing out shareholders, that does not arise. What is the involvement of creditors? In merger, creditors have to give sanction. Section 230 schemes require creditors' approval as well. Liquidation, voluntary liquidation also requires creditors. If the company has creditors, approval of creditors is required in voluntary liquidation as well. That legal part my colleague Barsha will be discussing later. Liabilities to third parties. Now, Section 53. Technically, Section 53 is applicable in voluntary liquidation as well, which means Section 53 is all about what? Section 53 is all about order of or sequentialization of the liabilities. Sequence, that is priority order, in which the liabilities will be paid off. Now, in voluntary liquidation, by definition, we are talking about sufficiency. We're talking about adequacy of cash. If you have adequacy of assets, the question of any sequence doesn't matter. Like I quite often give this example, so I'm repeating the example which I take very often. If we have enough food for all the invitees, in what order people eat their food doesn't matter. But if the food on table is only for 10 and there are 25 people eating there, the order in which people go to fill their plates that becomes very important, because who fills the plates first? Those who remain in the lunch queue after the food is entirely been eaten up. What will they? They'll get nothing. They'll get what you call haircut. So insolvency is a case of insufficient food on the table, whereas solvency is a case of enough food is there for everyone on table. Therefore, come and eat in whatever sequence you come, doesn't matter, because we have enough food for all. However, Section 53 is still relevant for two important reasons. Number one, who knows? We thought the company is solvent. We thought that the company is solvent. Directors thought the company is solvent. They signed on a declaration of solvency. But as the situation emerges, maybe the assets don't realize as much as they were expected to realize, and therefore we detect, maybe we are surprised by this revelation, but maybe that the assets are not sufficient. If the assets are not sufficient, we would have paid, let's say, junior creditors first. The seniors may be left unpaid, so that would be extremely unfair. Therefore, we still need to follow Section 53. Another implication of saying that Section 53 still applies is that when it comes to priorities in the shareholders, there might be preference and there might be equity. So we need to pay the preference first, because that's also part of Section 53. Preference, that's also part of the what do you call contractual rights of the shareholders, but that's also covered by Section 53. In terms of priorities, we pay preference holders first before we pay the equity. So when we say sufficient assets, I'm not saying the assets are sufficient to pay both equity and preference. The assets may be sufficient either not to pay preference at all. That may still be a case of voluntary liquidation. I'll give examples of that as we proceed. So Section 53 is still applicable. There is a need to have a professional, insolvency professional. All of you are here today because you look forward to having a role as a liquidator in voluntary liquidation. I can assure you that voluntary liquidation is far less problematic. जैसे अगर आपको लगता है कि liquidation, IBC वाला liquidation section, insolvent company का, वो liquidation is almost like putting a cap of thorns on your head. दिन भर खचखच, दिन भर टेंशन, दिन भर मारापीटी, कोई कुछ आपको बोल रहा है, कोई आपको कुछ बोल रहा है, कोई आपको, सब आदमी आपको दोष दे रहे हैं. सभी चीजों के दोषी आप हैं, एकमात्र दोषी आप हैं. जो भी कंपनी में हुआ 5-10 साल में, 15 साल में, सबका दोष आपके सर माथे. ये जो सिचुएशन ऑफ सो मच ऑफ स्ट्रेस, I would say in voluntary liquidation, there is much lesser stress. Because we're talking about sufficiency. जहां insufficiency हो तो वहीं पे stress होता है. Voluntary liquidation by definition the case of sufficiency, and therefore we have much lesser stress. Stress कम है. I'm not saying time taken कम है. Time taken is at the speed at which NCLTs function, so that might be a long drawn matter. So much less stressful. So if you're looking at, let's say, lesser stress in life, or more what you call comfortable zindagi आपको जीनी है as an insolvency professional, so I would say voluntary liquidation is definitely less straining, less paining, less draining than insolvent liquidation, or for that matter, CRP1. Back on the point. So then we were talking about role of NCLT. The NCLTs come at the end. In case of a merger, the scheme itself requires approval of the NCLT. In case of voluntary liquidation, we are not looking at NCLT as the starting point. We're looking at NCLT only at the ending point. When everything is done, you file a report of completion and wait for the NCLT to give a dissolution order. There is a proposal that may be going forward. The dissolution order also may be dispensed with, and maybe the IBBI or ICSI, IPA may actually write to ROC for dissolution. But that's I would say, proposed amendment. Let's see if it at all comes. Now I'm saying mergers are tax neutral. Mergers are tax neutral both as between the companies as also for the shareholders. Transfer of undertaking that happens from transferor company to transferee company. The assets may come either at book values, assets may come at fair values, depending on whether you're doing a merger as per pooling of interest method or you're doing a merger as per purchase method. For most companies which are covered by Ind AS, the only option now is to use the purchase method. Therefore, assets and liabilities may come at fair value. There might be a fair value based transfer, there might be a book value based transfer. And well, the transferee company, which is the transferee, is issuing shares mostly based on fair value only. So consideration is actually being paid to shareholders based on fair value of assets and liabilities. However, on the transferor company, there is no capital gain implication. By virtue of Section 47, carry forward of losses is also allowed in terms of Section 72A. If you're doing a demerger in terms of 72A by 4, there also carry forward of losses is allowed. So carry forward of losses, carry forward of unabsorbed depreciation, carry forward of a MAT credit, carry forward of several benefits is possible in case of a scheme of merger. Besides, mergers are also tax neutral for the shareholders. If the merger meets the conditions of amalgamation as defined in the Income Tax Act, then the merger is tax neutral for shareholders as well. As compared to this, voluntary liquidation is neither tax neutral for the company, all the more not tax neutral for the shareholders. Because to the extent the company is releasing accumulated profits, I'm repeating, very important point, and therefore I need to repeat so that people can easily compare what happens in a case of voluntary liquidation. To the extent there is an accumulated profit, reserves and surpluses accumulated in the company, and the company is releasing those accumulated surpluses, that is taken as dividend by virtue of the definition in Section 2/22C, and therefore this release of profits by the company to the shareholders will be taxable as dividends in the hands of the shareholders. Now that there is no dividend distribution tax, the tax is shifted to shareholders. So if shareholders are getting a release of distributed profits, that amounts to dividends under Section 2/22C. One can probably say, well, if the company has equity and preference capital and the company does not have accumulated surpluses, then where is the question of tax? Well, then there is no question of tax, because dividend tax or Section 2/22C will come into picture only when there is release of accumulated profits by the company. Now, there might be further tweaks into that. For example, before we distribute the profits, if we were to capitalize the profits and let's say issue bonus shares, we issue bonus shares and then we distribute the bonus shares, that is also taken as distribution of profits. Bonus itself is not distribution of profits, but the day we release the bonus share, the day we cash out the bonus shares by way of a voluntary liquidation, even that is taken as a case of dividends. So I think the essence of all this discussion is that any release of profits that happens in voluntary liquidation will result into tax as dividends in the hands of the shareholders. Now, what if my shareholder happens to be another company? My shareholder is, let's say, holding company. If my shareholder is a holding company, it may still avail the deduction under Section 80M. That is, to the extent that company itself distributes profits, it may set off the profits it's getting from the subsidiary company against the dividends distributed by the company itself. So tax implications on a voluntary liquidation will be a very important point to compare. Whether we should actually go for voluntary liquidation, can we think of other ways? That becomes a very important comparison before we actually think of voluntary liquidation. Dear friends, I have not even come into what exactly is the process of voluntary liquidation, because I think before we come into procedure, before we come into law, it's very important to understand first in what circumstances, for what reasons, for what kind of motivations a voluntary liquidation works. I would strongly suggest that any professional should go beyond acting as a procedural, and we are not merely procedural advisors. We are not simply people handling processes. We have a more important role to be able to advise clients what is ideal under circumstances. Those who are able to evolve as advisors will probably have will be able to provide far more value addition to clients than those who are simply handling procedures. So at this stage, I must ask you if you have any questions so far. And before we get into, I can see some hands going up. If you would like to maybe speak, Sanjay ji and others, if you have any questions, you would like to either raise hands and speak the questions, or maybe if you want to post questions on the chat, whichever way. But let's hear the questions. Sanjay Khandelwal ji.
Yeah. So my question is, voluntary liquidation, you said that assets can be distributed in specie. And the tax implication under dividend is 222C. When assets are distributed in specie, that means, let us say the company is holding shares which are distributed to the shareholders of the company. So how will the tax under 222C work on this?
Fair value of the assets. The fair value of the assets will be taken, and if that fair value exceeds, or fair value includes what you call accumulated profits. So when we distribute the assets, we are distributing two things. Number one, we're distributing the share capital itself. To the extent we're distributing share capital, there is no question of a tax, because that's what the shareholders had contributed, they're getting it back. To the extent we're distributing more than the share capital, that's when the accumulated profits comes in. Okay. So to the extent the assets are carrying or having a fair value higher than the paid up capital, there'll be question of dividend tax in terms of section 222C.
Okay, thank you.
Pushpal Sangavi, and then maybe Shashi Bhushanji.
Yeah, good afternoon, sir. My name is Shashi Bhushan.
Good afternoon.
Actually, I just wanted to know if there is an asset with the company which can be sold during the voluntary liquidation. So what will be the implication, tax implications?
Oh, you're saying if during voluntary liquidation I sell off assets?
Yes.
And let's say I sell the assets at more than the carrying value.
Right.
More than the cost or WDV or cost for tax purposes. Right. Cost for tax purposes might be, in case of depreciated assets, might be WDV. In case of non-depreciable assets, it might be the actual cost. So that, right. I think let's frame the question in a little wider context. Yes. If there is any taxable income, including taxable capital gains, during the process of voluntary liquidation, question is it taxable? Answer is very clearly and certainly yes. The fact that the company is under voluntary liquidation does not impact the tax obligations of the company. If the company is making any income, very often income during voluntary, because the company ceased to be going concern, so that way business income stops. But there is still money lying in the banks. There might be still fixed deposit. There might still be some investments. So either there is some regular income by way of bank interest, etc., or there might be a past refund of income tax, which also comes along with interest. So quite often interest is a very common scenario. That apart, if you're selling assets, for example, you're selling investments, you're selling some surplus land, there might definitely be a question of capital gains. Each of these are taxable in the same way as would be applicable for a company, for a normal company, a company under not under liquidation.
Okay, thank you, sir.
Same way goes for GST also. If you're doing a disposal of assets, GST is also applicable. So the fact that the company is under liquidation, voluntary or compulsory for that matter, will not impact either the tax liabilities, including GST tax liabilities, or the tax compliances. For example, if you're making payments, deduction of tax is applicable, filing of TDS returns is applicable, filing of IT returns is applicable. So in short, I would say everything works exactly the same way and continues to work the same way as it does before liquidation. Only thing is IT returns are filed by you.
Yes, sir.
All returns are filed. All compliances are to be done by you.
Thank you, sir. Thanks.
Pushpal ji.
Like voluntary liquidation of a Section 8 company.
Section 8 का liquidation ही नहीं होता है.
So voluntary liquidation is
कोई भी
possible
liquidation.
for a section.
So Section 8 company में कोई भी Section 8 company can never release even 1 rupee of its capital to its shareholders. So there is
Right.
nothing. So let me just quickly say, nature of Section 8 company क्या है? कि we have put money for a not for business cause, and that money for all time to come will remain dedicated to that cause only. No way can the money flow back to shareholders at all, either in form of managerial remuneration or in form of dividends or in form of repayment of capital. So there is absolutely no possibility of a voluntary liquidation of a Section 8 company. All I can do is to merge a Section 8 company into another Section 8 company of similar objects. That is
But
the
if
only.
But sir, if that company transfers it entire, the asset, the surplus asset, to another Section 8 company with the same object, can't it go for a voluntary liquidation?
What will happen to the money?
It will go to another Section 8 company, which
so
will again use it for that purpose.
So voluntary liquidation means the assets have to go to shareholders. Section 8 company cannot distribute to shareholders. So what you are therefore, Pushpalji, what you're saying is basically same as merging the company to another Section 8 company.
No, so there have been quite a few cases in which voluntary liquidation of Section 8 companies have happened. For example, Skills for India. So that there is an order to that effect, and that is the reason I'm asking technically, because liquidation is not, say strike off is not possible for a Section 8 company. It is very clearly mentioned in the section.
No question of strike off. To my mind, you said Skill for India.
Yeah, Skill for India.
Okay, we will like to maybe search for this ruling and see what is the argument. So as far as we understand Section 8 companies, and some of my colleagues have also written a separate piece on distributing relegation of money. Use of surplus funds in case of Section 8 company. What can I do with surplus funds? A Section 8 company में surplus हो गया, तो it will be used for that purpose only. It cannot go anywhere else for lifetime. There's no way by which a Section 8 company can ever release that money for any purpose whatsoever. So in the case that you're talking about, if I transferred my activities to another Section 8 company and transferred the benefit of capital to another Section 8 company, that's as good as merger only. Shareholders have got nothing. Whether we use Section 59 or we use Section 230, it should all be the same. So essentially a Section 8 company has to fold itself into another Section 8 company. It can never result into any distribution in any form to the share. Otherwise, the whole purpose of Section 8 will go away, because Section 8 is essentially meaning I'm altruistically, with no selfish motive, I'm setting aside property. I will never claim the property back. I'll never expect any benefit out of the property in whatever way. That's the whole intent of Section 8 company. But we will anyway search for this ruling, Pushpalji.
I can, I have it. I don't know how do I share it, but I have that ruling. Not
big problem. We can maybe write the link on the chat and we'll take it from there. But I said, without even reading the ruling, I would still, since you yourself mentioned that the capital also in that case was transferred to another Section 8 company. As long as we're transferring all the assets and all the usufruct or proceeds of the assets to another Section 8 company, no benefit is going to any shareholder in that sense, then there is no concern, there's no issue. In fact, even when I convert a Section 8 company into non-Section 8 company, even at that stage, if there's a profit, the profit has to go to IPF.
Okay.
The Section 8 company is like setting aside money to public good forever. जो भी Section 8 company खोलते हैं, इनको सोच के करना चाहिए कि पैसा वापस मेरे हाथ में नहीं आएगा कभी.
Right. Okay. Thank you.
Mr. Vinod Kumar Shah.
Yes, sir. In fact, I had taken a company for voluntary liquidation in May 2019. There was no claim from the income tax department. Subsequently, the income tax department has raised a claim that 59 lakhs are due, and that amount has been drawn based on the fact that in the assessment year, they have disallowed certain expenditure. And on account of that, they have imposed a penalty of rupees 59 lakhs. In fact, the matter is that even if the expenses are disallowed, company is under losses only. So it makes no difference. However, the penalty has been imposed.
Additional tax arises.
Uh,
Even the loss is reduced, then also there is additional tax.
That's true, sir. But it was subsequently there was no claim. Now my question is that liquidation proceedings is already started. So can this department raise a demand? And for that,
so I got your question. So you're saying that we served a notice in terms of Section 178. There was no response from Income Tax Department. Therefore, we were free to distribute the assets. We could have actually gone ahead and distributed assets. But the process of liquidation is still going on. The assets are still there. There is a tax demand. Vinod Kumarji's case is that even though there is a disallowance of expense, but that doesn't still lead to a positive income. The income is still negative. The losses have been reduced, but additional tax will still be imposed because that's in terms of Income Tax Act, that's a wrongful claim. So the tax officer may impose penalty, he might impose additional tax. That happens very commonly, and you can actually go for appeal and make a case that there couldn't have been intent. At least the penalty can be saved. Additional tax, to my mind, will still be there, but penalty may be dropped because penalty, the mens rea is not there. The penalty may be stopped actually. You can go for that. But question is that even though we apply Section 53, question of distributing funds to shareholders will come only after all liabilities are paid off. So logically, the demand of the Income Tax Department, to the extent it still remains after your waiver of penalty application, you will still have to pay if you have funds already. If the funds have already gone to shareholders, sorry, I'm just continuing. If the funds have already gone to shareholders, normally when we do interim distribution, normally, and that's my strong suggestion to all IPs, whenever we do interim distribution, we should always do with a clear caveat in the covering letter to say that if at all any liabilities come, either because of expenses or because of any external liabilities, or there is an NCLT order against it, etc., or maybe the process of voluntary liquidation gets converted into involuntary liquidation. Either way, the distribution is held to be reversible. Then the recipient of the money, the shareholder, will remain liable to refund that distribution should it be so required. Now, practically, I know it's very difficult. Once the money goes to recover the money from a shareholder becomes very difficult. But if you have, let's say, a holding company or a few shareholders and the money may be needed, my colleague will say that very often, even for expenses, we might have to get the money back. They might sometimes be employees' expenses which were not known earlier. Subsequently, expenses come up. We have distributed the money to shareholders. So we make the shareholder understand, भैया देखो मैं क्या कर सकता हूँ, मेरे को नहीं मालूम था. We have distributed money, and the money is now required for the expenses or for the tax liability. So you might have to, I mean, to my mind, I would say in terms of law, the tax liability will have to be settled still.
Sir, in fact, I have made appeal also, but somehow appeal is not coming up for hearing in spite of the repeated reminders. Secondly, I have got funds because I have not distributed whole amount. So amount is there. Can I go to the NCLT saying that claim of the demand of the Income Tax Department is not tenable?
So, sir, NCLT cannot decide on the tenability or otherwise of the income tax. NCLT cannot sit in judgment over tax matters. Whether
But
the
sir,
demand,
this is after the commencement of liquidation.
That's okay. The fact that liquidation has commenced doesn't mean liability cannot arise thereafter. Any liability can arise thereafter. In fact, a lot of liabilities, I'll be discussing a little further. There may be plenty of liabilities which might come up after commencement of liquidation. Commencement of liquidation is not end of corporate existence. The company still continues. Until dissolved, the company is still in existence. So the company can have all liabilities. So Vinod Kumarji, if you have money, I would say for the penalty, you can go for a waiver application, which I think mostly will be positively taken by the tax department because there was no intent to breach the law. But additional tax, I would say, would still be payable. You can pay off the liability and then go for distribution. Going to NCLT will not help. NCLT will never decide on income tax matter. And it's not a law that once liquidation commences, there cannot be a further claim. We know that claims come even in case of compulsory liquidations.
Sir,
So I think Vinod Kumarji's continuing question probably was not heard, but Mr. Sanket.
Sir, I repeat, can I go to the NCLT for an application for dissolution and giving all the facts and making the party to the income tax department also?
So why do you want to do that? No reason for doing it. I don't suggest it surely, but there's no reason.
Okay, sir. Thank you very much, sir.
Mr. Sanket.
Yes, good afternoon, sir.
Good afternoon.
There are two queries which I have.
I'm so sorry. By mistake, I muted. Very sorry about this. Yeah, Sanket, very sorry. Kindly repeat.
Yeah.
Sorry.
So my first query is regarding voluntary liquidation of LLP. Now, the challenge is that there are no specified forms for LLP, as we have say MGT 14 or other forms for ROC intimation when the liquidation or voluntary liquidation commences. Similarly, there are no forms for LLP. That is one. And also, there is one problem that we have been cited by ROC that there is one circular dated March 2020, as a result of which the communication for the liquidation needs to be made to IBBI and the e-governance cell of Ministry of Corporate Affairs, and then they will intimate the ROC, and after which the status will change. Now, because of which there are a lot of problems faced in closing the bank accounts, existing bank accounts, and again, opening the new bank account. So this is one challenge which I am facing, and through your medium also would like to raise this. That is one. And my second query is regarding bank guarantee. So suppose the company is into say ETP installations, turnkey installations, and they have given the bank guarantees say 4-5 years back, and the period of bank guarantee is also over already as per the agreement. However, when we are going to bank for the liquidation of FD, which is given as a security for the bank guarantee, they want the release letter or something of that sort. So the challenge is that the department also, government department also has misplaced the BG being a client in their transfer of some offices. So how do we address these two issues? Thank you.
Mr. Sanket, the first issue about LLP that you mentioned, this is not something that I would be able to anyway address, because this is, you're saying this is because of some MCS circular. So maybe take it up with IBBI. IBBI is voluntary liquidation team, I think, should be able to help on that.
Yes, sir. Yes, sir. Thank you.
The second question is, I would talk generically about the continuing obligations of the company. The specific case that you're referring to is extremely factual, because there is some BG lost by some department, therefore the BG is not getting released, etc. That becomes very, very specific to the particular case. I'm not sure whether I'll be able to help on that. But I will talk about something which is very generic and very important. We said precondition for voluntary liquidation. Precondition is what? Number one, the company must be solvent. Everyone knows. The company must be solvent, meaning what? As on date, the assets are sufficient to pay off liabilities. As we start on the liquidation path, we assess the value of assets. We look at the liabilities and we see, well, the assets are sufficient. Going forward, it may so turn out that there might be further liabilities. The assets may deplete in value. And therefore, we might actually have to make an application to NCLT to convert the process from voluntary to involuntary liquidation, because voluntary liquidation cannot be proceeded with. The process will have to stop if we detect that the company is not solvent. That's one condition, which is something that everyone knows. But there are very important hidden obligations or continuing obligations of the company which may be stumbling blocks to voluntary liquidation. So there should be no contractual bar, because voluntary liquidation starts by the company passing a resolution of shareholders for voluntary liquidation. The starting point of voluntary liquidation is what? Shareholders pass a resolution that the company may be liquidated under Section 59, voluntary liquidation resolution. You'd probably recall that when we do several contracts, many contracts that we enter into, we have a clause called events of default. Now, if you mentally try recalling what are the things that we include in events of default, if you try recalling it, probably most of you would be able to recollect that among the very first event of default in most agreements would be passing of a resolution for winding up. In a sense, passing of a resolution for winding up is an EOD, event of default, in most business contracts. So now what does that actually mean? If you have continuing business contracts or continuing obligations under business contracts, there may be plenty of contracts into which the company might have entered into, and those might be long-term contracts. Let's say I've got a long-term supply contract. For next 5 years, I'm supposed to supply some material or raw material or inputs to some particular company. I have a long-term supply contract. I might have a long-term, let's say, employment contract. I might have a guarantee. So my company has given a guarantee. If a guarantor having given a guarantee without getting a release from the beneficiary of the guarantee, the guarantor passes resolution for winding up, that itself triggers event of default. That would mean the guarantee itself can be invoked then and there. I don't have to wait for the guarantee to be invoked. Invocation of guarantee will immediately happen if I pass the resolution for winding up. My guarantee will be invoked. I'll be liable to pay money. Similarly, I might have entered into derivative contracts. In derivatives as well, definition of EOD includes passing of a resolution for voluntary liquidation. So please understand that the company in question does not have any such continuing obligation, contractual obligations. Under continuing contracts are over, contracts have been performed, everything is over, no issue. But if there are contractual obligations for any kind of a continuing contract, then that itself will act as, we'll have to think. I'm not saying that's a bar on voluntary liquidation. You have to think that maybe passing of that resolution itself will trigger some EOD, which might bring some contractual obligations on the company. The company may be required to compensate. The company might be required to pay liquidated damages. The company might be required to pay a security deposit. So we'd have to think of what all might be the implications of passing this resolution. So please don't take a straightforward approach and have resolution passed, because passing of this resolution may have serious repercussions. In the context that Mr. Sanket has asked, there's a guarantee, but the guarantee is probably due to be released. However, as he says, the BG papers are not there with the government department to which BG has been given, etc. So maybe the papers are not available. So that's a practical thing. I mean, unless the guarantee is released, I mean, there's a FD given to back up the guarantee, so you're not able to get release of the FD. Perhaps you might have to wait. The voluntary liquidation process itself might take some time. Sometimes there might be similar deposits with some statutory bodies. For example, a deposit is lying, let's say NSE. You had some kind of a license with NSE. There is a deposit with NSE. Sometimes there might be pending refunds. There might be some pending deposit with some government department. Just because you pass a resolution for winding up does not mean you'll get a refund of the money. So you have to think of in what way can I release this money. Sometimes you might have to therefore think of an in specie distribution. That even this deposit, I can distribute in specie by distributing the money to a shareholder. If there are 1 or 2 shareholders, all this is possible. If there are multiple shareholders, I don't think we have the option of in specie distribution. Mr. Sonu Deepak. Sonaji, go ahead.
Hello, sir.
Hi, Sonu. Hi.
So I also, sir, had a similar kind of a query in my case. We had submitted the liquidation notices with all the departments, but did not receive any claim or any response from any of the departments. But later we received, show cause notices from GST authorities. So, sir, like you just said that it is quite possible that you receive claims later. But then, sir, the liquidation process being a time-bound process, then that goes for a toss, right? I mean, entertaining the department's demands and notices, then how do we put an end to this process?
I wish I had an answer. Like most IBC processes, it's supposedly time-bound, but rarely completed within time. So liquidation, I mean, compulsory liquidation is also time-bound. 1 saal ka time hai. But many processes have completed 5 years of existence already with no end in sight. So wherever the process is dependent on actions of third parties, you'll probably have to file an annual report, what you call annual performance report, giving reasons why you couldn't complete the process in time. But
that is we have already filed twice, sir, for 2 years.
Others might have done 4 or 5 times.
But there should be some end to it, either some stern steps that the liquidators need to take, that they outrightly reject such claims which are being received after, you know, expiry of not just 30 days. I mean, it's not that you have to come back in 30 days, you come back in 2 months, 3 months, 4 months, or 6 months, or 8 months. But I mean, if the authorities come back after a year or so, when you're at the brink of, you know, just going in for the distribution of funds, and then you receive show cause notices from the authorities. So this is somehow, you know, defeating the whole process of liquidation.
No, if you talk about advocacy, then I'm with you. I advocate the same point. There has to be some timeline. There has to be some end to it. It cannot just continue. Just people cannot just continue to sleep for years and ultimately wake up and take the liquidation process for a toss, as Sonuji says. But I think that's advocacy. Reality of life is that life is as bad as Sonuji, you are saying it is.
In your opinion, we'll have to entertain those claims and notice.
We have no option but to, we can fight them out, but how does it help? Would we be able to get a satisfactory disposal of the appeal, let's say within, we are
that's a separate issue altogether.
So we are not here crusaders. In this process, we are not crusaders. I think we are not fighting a crusade. Advocacy is separate. We can continue to advocate and we probably say, well, I should do something about it. That's a separate issue once again. But if there is a claim, I have to either settle it or I have to decline it. If I decline it, then the department will start prosecuting. They'll say, next thing they'll do is will send a prosecution notice. So you don't want to be on the wrong side of the law and face prosecution. Therefore, if there is no bona fide reason for defending the liability, I would suggest pay it off if you still haven't distributed.
Thank you.
Okay, right. What I'll do, and Sunilji, yes, quickly maybe this question before I'll take us some illustrative examples of distribution and voluntary liquidation. Sunilji, go ahead.
Good afternoon, sir. Actually, I just have one query similar to Sonuji just asked, but you know, in relation to that, in voluntary liquidation, you know that as per regulation 37, we need to complete the liquidation process or proceeding within the time period of 270 days. And as per clause B, in case if the there is no creditor in the company, then in that case it need to be completed within 90 days from the liquidation commencement date. So under such circumstances, for example, like there is a regulation, there is a section 178 requirement also of the Income Tax Act, wherein we need to intimate to the Income Tax Department, and the liquidator cannot leave part of the assets of the company. So there is a time period of 3 months wherein it is mentioned that we need to, you know, the income tax officer need time of 3 months, and here is also time of 90 days. And if we have, you know, some income tax refund which is available with the company, and we, since if they are not proceeding within such time period, so how we need to close this process, number one. And number two is, yeah, sir, I'm sorry. Number two is that, you know, there is no process, process, I would say, of filing of any application also before the NCLT unless we file the final report or the compliance certificate. So how we should deal with such situations, sir?
So, देखिए, सुनील जी and सोनू जी and others, इस मामले में आपका दुख और मेरा दुख एक ही है. तो हम सबके दुख एक ही, हम साथ मिलके we can probably shed tears. We are all together when it comes to shedding tears on this. So these 90 days, 270 days, 1 year, whatever number of days or whatever number of years are timelines set by the regulators. And we all know how impractical would it be in circumstances to actually abide by it. So we just have to cite reason, that the reason why it couldn't be settled within 270 days is because there's a pending refund. Pending refund तो कुछ साल नहीं आता है, वो कहाँ 270 days 4-5 साल नहीं आते हैं. And then I mean and when you start pursuing, you'll probably get it. The Sonuji's case is that we deduct past liabilities when you go for refund. When you go for refund, the tax officer digs, there is a past liability, आपके खिलाफ एक liability पड़ा है, आपको मालूम नहीं था. So this is something that's a reality of life. We cannot deny it. So I don't think there is a way to have any satisfactory answer to the problem, Sunilji, you mentioned. There are no answers actually. So as I said, we can crib about it, but there's no answer, unfortunately. So I was just giving some, right, Sunilji, I was just giving some examples of how distribution happens, a very little tricky, I would say, classroom type examples to illustrate the process. But before that, I'll quickly take little further time to say, in terms of statutory provisions, Section 59 is the main provision under which voluntary liquidation happens, but by virtue of 59/6, sections 35 to 53 of the IBC are also extended to voluntary liquidation. All sections starting from 35 to 53, mutatis mutandis, are applicable to voluntary liquidation as well. Now, this importantly might include number 1, section 36, the delineation of liquidation estate, things which are not part of liquidation estate. By virtue of section 36, certain things are part of liquidation estate, certain things are not part of liquidation estate. That will be applicable to voluntary liquidation as well. Importantly, quite often a question comes about section 43, 45, 49, and section 50. These sections, what you call, PUFFE, preferential transactions, undervalued transactions, fraudulent transactions, and fraudulent, extortionate lending transactions. These sections are also applicable in case of voluntary liquidation too. If these sections are applicable in case of voluntary liquidation as well, question is, shall the liquidator in case of voluntary liquidation also examine past records to find out have there been any preferential transfers, avoidance transactions, extortionate credit? I think the likelihood is not there, but let's say fraudulent, undervalued or fraudulent transactions. 49, transactions for defrauding creditors, fraud, whether the liquidator has to do an examination for these so-called vulnerable transactions as well. The answer is very clearly yes. Now, reason why yes. In case of insolvent company, there is a very good motivation. There's a strong motivation, I would say strong compulsion for companies or management to do preferential transactions, undervalued transactions, because they're all busy in trying to save the assets, trying to give preference to some people, trying to pay off to those who are preferred creditors, etc. The compulsion is very easily understandable. वो मरता क्या नहीं करता वाली बात है. तो वहां तो motivation is बहुत clear. लेकिन when it comes to voluntary liquidation, we're talking about sufficiency. Everything is sufficient. Things are adequate. So what will be the motivation for a company under voluntary liquidation, a company which is solvent, to do undervalued transactions, preferential transfers, etc.? I would say let's not forget that in voluntary liquidation also, the equity and the preference shareholders may be getting haircuts. Preference shareholders may be getting haircuts. Equity में तो haircut बोल के concept नहीं है. Equity में जो बचा वो मेरा है. जो बचा कुछ है उठा के लेके जाएगा. That's the right of the equity holder. But the interest of the preference shareholders and the equity holders may still be impacted by vulnerable transactions. So there is no reason to rest in peace and not do an inquiry or preliminary inquiry at least into the working of company for detecting transactions which are preferential or undervalued. So these sections, I would say, are equally applicable to voluntary liquidations as well. Now, I'll just take quickly some very, I would say tricky classroom type examples to illustrate how distribution happens in voluntary liquidation. So let's assume that the assets of the company, let's say assets in liquid form or let's say cash is 1,000. The share capital is 500. Preference capital is 900. And the outside liabilities are 100. So the situation is we have 1,000 rupee of cash, liquid assets, liabilities of rupees 100. Therefore, once we pay liabilities, we are left with rupees 900. And the preference capital itself is 900. Assume for a minute, preference capital is 1,000. And the equity capital is, let's say, 500. So preference capital 1,000, equity capital 500, assets remaining after settling liability only 900. First of all, are we satisfying the condition for voluntary liquidation? Is the company solvent? Solvency is determined by seeing, do we have sufficient money to pay outside liabilities? So there we will not take preference capital as a liability. If it was debentures, it would be a liability. Preference capital is not a liability. Preference capital is capital. It's a share capital. So it's not a case of liability. Therefore, condition of voluntary liquidation is satisfied. After settling the liabilities, we will first pay money to preference holders. So the entire remaining amount 900 will go to pay preference capital. Nothing is paid to equity. Equity gets a full haircut. Second situation, let's assume, once again, same cash of 1,000, debt of rupees 100. Let's say preference capital nominal value is 900, which includes premium of rupees 400. So the total amount contributed by preference is 900, including face value 500 and a premium of rupees 400. So in what is the manner of distribution? Once again, 900 will first be paid to preference. But question is, how much do we pay to preference? Shall we pay the entire 900 or do we pay only the face value? Answer is premium on issue does not necessarily mean premium on redemption. We will care for premium on redemption, but not premium on issue. So I don't have to pay the premium on issue because that's absorbed and adjusted immediately after issuance. There's no question of paying premium. So I'll only be paying the par value, and the remaining value will go to equity holders. Another example, if we had a premium on redemption, that will be captured as part of the payable to preference holder. So we'll pay the preference holder par value as well as the premium on redemption. This is just quickly to illustrate how we determine the existence of solvency and how do we, in what order do we pay to which stakeholders. Of course, we pay the creditors first. While paying the creditors, we'll proceed in terms of Section 53 priorities. Priorities wouldn't matter if you're not apprehending a shortfall, but when it comes to the shareholders, we will still go by the priorities. I should have actually asked Trashlaji, but maybe I can ask now. Trashlaji, we began at about 1 o'clock. It's about 1.5 hours. Do these people participating here, do they deserve a short break, or do you want me to still?
No, sir. We can take break. That's not an issue.
Achha. Okay. So Trashlaji is very good in permitting you all to take a break, so that like other punishments, including acting as a liquidator, this session doesn't become as punishing, as punitive. So maybe I think if all of you are okay, can we take a 10-minute break? And as we come back after the break, all of you, I hope, are okay with 10-minute breather for all of you.
Sure.
And then as we come back after the break, right? Thanks. And as we come back, my colleague Barsha will take over to talk about rest of the provisions of voluntary liquidation. I'll be there, but in the background, and she'll be the one handling it. Thanks.
Thank you. Thank you.
Is there a break?
Yes, we are on a short break, so that's why you're not able to hear. We took a small break just to allow people to take a little breather. Barsha, if you're there already, you can just turn your.
Yeah, I have not given it to someone, but sorry.
Barsha, if you're there already, you can turn your audio and video on and please
Yes,
start.
sir.
You can start.
Right, sir.
Wait, yeah.
So I hope everyone is back from the small break and we can now continue with the session now.
Yeah.
I'll
Right.
just quickly share my screen. Yeah, I hope it is visible to all.
Yes, ma'am. Yes, ma'am. It's visible.
Okay. So far, Mr. Kothari has already discussed regarding the eligibility of a company that intends to opt for voluntary liquidation process and the things that one should keep in mind while one is deciding to close the affairs of this company by way of opting this voluntary liquidation process. What one should, what should be the procedure and how to follow the what is there in the code, what is the overview about the process. I'll discuss that about now. So in Insolvency and Bankruptcy Code, section 59 read with IBBI Voluntary Liquidation Regulation 2017 deals with the voluntary liquidation process. Apart from this, section 35 to section 53 of the code is also applicable with appropriate modification in the voluntary liquidation process. When we say voluntary liquidation process, we mean that a company which is solvent is intending to close its affairs and now is opting for this voluntarily liquidating itself to close its affairs. Now, when it comes to section 59 of code, it says that voluntary liquidation process starts from a date of passing of resolution by the shareholders of the company. So we'll discuss about the liquidation commencement date as to what should be the trigger date of commencement of liquidation. When we talk about commencement of voluntary liquidation process, of course, the process starts from the board resolution when board of the company decides to liquidate the affairs by way of a voluntary liquidation process and appoints insolvency professional to act as a liquidator for the entire process. What are the things that one should keep in mind while drafting the board resolution? That also I'll discuss in brief. And then the triggering point, which is liquidation commencement date, as to what should be the liquidation commencement date when there are creditors in the company. So before discussing this procedural part, the first thing which Mr. Kothari has already discussed as to what will be the eligibility of a company that is intending to opt for the voluntary liquidation process. So under IBC, it clearly says that the company should be solvent. The assets of the company should be enough to pay off its liabilities. So this is the precondition where a company is opting for the voluntary liquidation process. Apart from this, unregistered company, foreign companies, financial service providers can opt for the closing of its affairs by way of provisions under Companies Act. Important preconditions for voluntary liquidation is no default. There should not be any default subsisting as on the date of commencement of the voluntary liquidation process. Declaration of solvency, which is one of the very major point when it comes to voluntary liquidation process, as to what declaration of solvency is all about, who are required to give the declaration of solvency, what is the manner, if at all there is any format provided in the liquidation regulations regarding this declaration of solvency. So I'll come to that part as well. Now, let us start with this declaration of solvency only. The provision says that majority of directors of the company are required to give the declaration of solvency. Question comes, if there are nominee directors in the company, are they also required to give the declaration of solvency? Probably yes, because it does not exclude any of the directors of the company from its purview. So majority of directors are required to give the declaration of solvency. Second question comes, if at all there is any format provided for the declaration of solvency. No, there is no format which has been provided in the voluntary liquidation regulation so far, but it says as to what should be the attachment in the declaration of solvency and what should be the content in the liquidation in the declaration of solvency. So the content of declaration of solvency should be, first, that directors are affirming that the company is solvent enough to pay off its liabilities. Second, is that the company is not being liquidated to defraud any of the creditors. And third thing, which has been newly added, it says that the director should also confirm that they have made a provision for the storage or retention of the records of the company. Now coming to the attachment part, as to what all things are required to be attached along with the declaration of solvency. So it says that the audited accounts of previous 2 years are required to be attached in the declaration of solvency. And this should also be accompanied by an affidavit by the directors of the company. Here, one practical difficulty that one faces is that, say, suppose the company in the mid of the year decides to liquidate its affairs, say on 5th of April, or say on 28th of April, the company decides to liquidate its affairs. The board resolution has been passed on that date, and the audited accounts is of 31st March only. Then whether if the company provides the audited accounts for the previous 2 years, will that suffice? Ideally, that should suffice. However, we recommend that the audited accounts as on date of passing of resolution, or as on the date of execution of declaration of solvency, should be there. Why the same is required? The same is required such that from the liquidation commencement date, the liquidator is required to prepare receipts and payments account. Receipts and payments account for the entire process of liquidation. During the entire process of liquidation, how the money has been received, how payment has been made, entire details are required to be recorded in the receipts and payment account. So if the account is updated, the liquidator will simply brought forward the balance as shown in the audited balance sheet in the receipts and payments account, and accordingly make the necessary edits there, or make the necessary insert the necessary details with respect to the receipts and payments made thereafter. And it will be easier in case of filing of income tax returns as well. Now coming to the this preconditions of voluntary liquidation process, which I was talking about, declaration of solvency is required to be given by the majority of directors. So what should be the date of execution of declaration of solvency? It says that as on date of account, or the date of execution of declaration of solvency, the liquidator, the directors are required to give the updated accounts or the statement of assets and liabilities, the exact position of the assets and liabilities in their declaration of solvency. So ideally, the date of passing of board resolution or a date prior to that should be the date of declaration of solvency, so as to give a concrete idea to the shareholders as to what is the current position of the company which is opting for voluntary liquidation, because ultimate authority with respect to approval of this voluntary liquidation process is the shareholders of the company. So the process starts with the approval of shareholders. Within 4 weeks of this declaration of solvency, the liquidator is required to directors are required to take consent of the shareholders of the company by way of special resolution. Again, when the documents, the chartered documents of the company itself provides the manner in which the company will be liquidated, in that case, ordinary resolution will suffice. If at all there are creditors in the company, in that case, consent of 2/3 of the creditors are also required to be taken. Now, what will be the date of commencement of liquidation? So the date of commencement of liquidation, when there are no creditors, is the date of passing of special resolution. The clock starts ticking. When it comes to when there are creditors in the company, in that case, the date of taking consent of the creditors of the company is the date of commencement of liquidation, and accordingly the entire processes has to be as per the set date of passing of date of taking consent of the creditors. Now the preconditions, as I briefly mentioned about, the company should be solvent enough, the company should not have committed any default, declaration of solvency must have been given by the majority of directors, passing of members resolution, and at the end, if at all there are creditors, then consent of creditors are also required to be taken. Now, qualification of insolvency professional to be a liquidator. Who can be appointed as a liquidator of a company which is opting for voluntary liquidation process? So qualification is similar to that of a liquidator in case of normal liquidation process, which says that the liquidator should be independent. Independent as in the liquidator should be, if the liquidator is able to be appointed in the company as an independent director, that person can be said as an independent to the company. Now, not only this, there are apart from this, there are other criteria as well, which says that if the liquidator if the person to be appointed as a liquidator in the company has been served the company as an employee or proprietor or partner in the at any time in the last 3 years as an auditor of the company, or as a secretary auditor of the company, or as a cost auditor of the company, that person will not be able to be appointed as a liquidator of the company. Apart from this, there are other criteria as well, which has been provided in Regulation 6, which says that in what condition a person cannot be appointed as a liquidator of the company. So whether the appointment of liquidator is also subject to the approval of shareholders, answer is yes. At the time of passing of board resolution, the board selects a person, an insolvency professional, to act as a liquidator, decides the remuneration, which are subject to the approval of shareholders. So at the time of passing of resolution by the shareholders, the consent with respect to appointment of the certain person as recommended by the board to act as a liquidator of the company is also required to be passed. Now, things to be keep in mind while drafting the board resolution and shareholders resolution. When it comes to board resolution, of course, the terms and conditions of appointment of the liquidator, what will be his fees, and the power should be given to the liquidator regarding operating the liquidation account in a scheduled bank. And apart from that, also with respect to the authority should also be given to the board of directors to appoint the necessary professional as he may require during the process of the liquidation for the assistance as he may require for appointment of valuers, appointment of auditor, etc. So these things are also should be taken care of at the time of drafting of board resolution. When it comes to shareholders resolution, approval with respect to the commencement of the voluntary liquidation, approval with respect to appointment of liquidator, his fees are required to be taken into consideration while taking consent of the shareholders of the company. Now coming next to the process, the timeline. So as I said, the moment the shareholders resolutions pass, the clock starts ticking. So every timeline which has been provided in the voluntary liquidation regulation starts from this particular times itself, from this liquidation commencement date itself. So initially, as I said, we are required to pass the company is required to pass the board resolution for obtaining the declaration of solvency and for the voluntary liquidation process and for appointment of the liquidator as well. After passing this board resolution and taking the declaration of solvency from majority of directors, the second thing which comes in the process is passing of special resolution or ordinary resolution. As I said, the special circumstances within 4 weeks of obtaining consent from the directors. After that, approval of creditors. If at all there are creditors in the company, then within 7 days of passing of the special resolution, consent of the creditors is required to be taken. After that, the liquidator comes into the picture. Once the liquidator is appointed, the liquidator is required to make the public announcement in Form A. A Form A is provided in the liquidation regulation itself, which says that what is the liquidation commencement date, by what time the stakeholders of the company are required to submit their claim, what will be the mode or manner of submission of the claim, etc. So that Form A is required to be, that Form A is basically a public newspaper advertisement format. So in that format, the liquidator is required to give the newspaper advertisement in 2 newspapers, one vernacular daily and one in English newspaper. These newspaper publications are required to be given at the place where the registered office or the principal office of the company is situated, in both the places basically. And apart from that, if the liquidator thinks that in this particular place as well, the company might have stakeholders, the liquidator should give the newspaper advertisement in that particular place as well. Copy of newspaper advertisement, copy of that public announcement is required to be given to the IBBI, and a copy thereof should also be uploaded on the website of the corporate debtor, if at all the corporate debtor has any website. So this newspaper advertisement is required to be given within 5 days from the liquidation commencement date. Now coming to the intimation to IBBI by IP. When it comes to intimation, giving intimation to the IBBI, there are 2 points. So one says that company, the corporate person is required to give intimation to the IBBI, and the other one says the moment the liquidator is getting appointed, the liquidator is also required to inform the IBBI regarding his appointment. Both the timeline is 7 days from the liquidation commencement date. So simultaneously, once the liquidation commences, the liquidator is required to give intimation to the IBBI about his appointment, and the corporate person is also required to give intimation to IBBI as well as registrar of companies within whose jurisdiction the company is being registered within 7 days of liquidation commencement date regarding the commencement of liquidation. Then coming to submission of the claim. So once I invite the claim, I invite the stakeholders to submit their claim within the respective forms. There are forms provided. I'll discuss about the forms later part of my session. So in the respective forms, the stakeholders of the company, with the financial creditor, operational creditor, workman, employee, etc., they are required to submit their claim with the liquidator. The liquidator is required to verify the claim within 30 days. After verification of the claim, the liquidator is required to prepare a list of stakeholders. After preparing the list of stakeholders, the liquidator is required to realize the assets. The liquidator is required to make distribution of the realized proceeds. And if at all there is an unclaimed or undistributed proceeds, then that money should go to the corporate voluntary liquidation account. If there are no such money, then the entire accounts has to be audited by an auditor appointed by the liquidator. And after that, the liquidator is required to file the final report along with dissolution application with the NCLT. So the role of NCLT comes at the end when it comes to voluntary liquidation process. And once the order of dissolution is being passed by the liquidator is required, passed by the NCLT, the liquidator is required to intimate regarding this dissolution of the company to the registrar of companies within 14 days from the date of receiving of the order. So this is the overview of the process that one has to follow once the company decides to opt for the voluntary liquidation process. Now, the timeline for the liquidator. So, as I said, the liquidation commencement date is actually a ticking point from which the actually the clock starts ticking. So, liquidation commencement date, within 5 days, the liquidator is required to make a public announcement. Within 7 days, the liquidator is required to inform the IBBI regarding his appointment. Within 30 days of the liquidation commencement date is the last date of receiving of the claim. So here, please note that 30 days from the liquidation commencement date and not from the date of public announcement is the last date of submission of the claim. So ideally, the stakeholders have 25 days time. If say suppose the liquidator is making announcement on 5th day, then the stakeholders have 25 days to make submission of their claim. What will happen to the claim if the claims are not submitted within the given time? That also I'll discuss in the later part of the session. So again, within 60 days, the liquidator is required to verify. Within 30 days from the liquidation, from the last date of receipt of claim, the liquidator is required to verify the claim. After verification, after accepting the claim, the liquidator is required to prepare a list of stakeholder. Now, when it comes to preparing the list of stakeholder, here again, the timeline has been stringed by IBBI. It says that if at all there are no creditors in the company, in that situation, within 45 days, the list of stakeholders and preliminary report should be prepared. And if at all there are creditors in the company, then the extended timeline, which has been provided earlier in the regulation, is still there. Then appeal by the creditors to the NCLT against the decision. So section 42 of the code, as is there in case of normal liquidation, is still there, is still applicable in case of voluntary liquidation process. It is that any of the creditor, if aggrieved by the order or decision of the liquidator with respect to rejection of his claim, then the said person can approach NCLT, can appeal to the NCLT under section 42. The liquidator shall endeavor to complete the entire process within 90 days if at all there are no creditors, and if there are creditors in the company, in that case the timeline is of 270 days within which the liquidator should endeavor to complete the liquidation process. However, if say suppose the timeline exceeds, in that situation the liquidator is required to present annual status report giving details of the work done by him till that date, details of assets realized, details of assets pending realization, details of distribution made so far, with audited accounts for that year in the annual status report, and the liquidator is required to present that annual status report within 15 days from the completion of 1 year to the contributories of the company, and also required to take consent of the contributories to proceed further to continue with the liquidation process of the company. Now, concept of declaration of solvency, as I already mentioned, this is the major part when it comes to voluntary liquidation process, as this is the base on which a company decides whether the company will be eligible to proceed ahead with voluntary liquidation process under IBC or not. So declaration of solvency, I have already given the content as to what should be there, what are the contents as provided in the voluntary liquidation regulations, what are the recent amendments made with respect to the declaration to be made by majority of directors of the company, and the attachments which should be there along with the declaration of solvency. It also says that if there are assets in the company, then the directors are also required to attach valuation report prepared by the registered valuer. So here, if at all the liquidator thinks that the valuation is required to be done at a later part, then liquidator may appoint the registered valuer. There is no compulsion on the liquidator to appoint the registered valuer, as because it says that in the declaration of solvency itself, if there are assets in the company, the directors are required to attach valuation report prepared by a registered valuer. Now coming to the phases of voluntary liquidation process, board's approval and shareholders approval. As I already mentioned, that one has to be very, very cautious when it comes to board's approval, because once the liquidation process commences, after that the liquidator comes to the role of the board, and after the liquidator is required to open the liquidation account with the scheduled bank account. The liquidator is required to close the existing bank account of the company. It's required to transfer the balance which are there in the existing bank account of the company in the liquidation account, as whatever payments will be done during the liquidation process will be done through this liquidation account only. So many times the insolvency professionals face issues or face concerns of the respective branch managers or bank officials when it comes to these resolutions. They ask for the specific resolution as to where the power has been given, show us the respective resolution. So one has to see that in the resolution, the particular resolution is been passed by the company, these provisions, these things are there, so that the liquidator should not face any issue once he is there on the board or once he is there on job. Liquidation commencement date, as I already mentioned, that if there are creditors in the company, in that case, the liquidation commencement date will be the date of taking consent of 2/3 of the directors of the 2/3 of the total debtors of the company. So say suppose the members resolution is passed on 18th of January and creditors approval has been passed on 25th of January. So in that case, the liquidation commencement date will be 25th of January. That is the date of taking consent of the creditors of the company. Consequences of commencement of voluntary liquidation process. So once the voluntary liquidation process commences, what after that? So once the liquidation process commences, the company ceases to carry on its business. The company is not required to carry on its business until unless that is required for the beneficial liquidation of the company, for the beneficial winding up of the company. So to that extent, the liquidator may carry on the business or may authorize the directors to do the needful as may be required. However, the business of the company ceases to exist. Directors of the company, directors will cease to hold the office, and the powers and duties of the directors will be there with the liquidator. There is a MCA regulation, MCA notification, which provides for the necessary filings to be done by the liquidator when it comes to voluntary liquidation process. It's a 2020 regulation which says that once the company passes the resolution for the voluntary liquidation, after that the liquidator is required to intimate to the register, the company intimates to the registrar of company. Also, the liquidator is also required to file one GNL2 intimating the registrar of companies with respect to passing of this resolution and his appointment. And in the GNL2, the necessary attachments should be there regarding intimating the registrar of companies with respect to the commencement of this process. And after that, there will be no filing of AOC 4 or MGT 7 as are required in case of normal companies. This circular does not explicitly excludes the company under voluntary liquidation from filing this filing these forms. However, it says that these forms are required to be filed till the date of CIRP only. So there's nothing mentioned regarding the voluntary liquidation process. It says that whatever filing to be done during the voluntary liquidation process has to be done by the liquidator. And in the form, one is required to select the position as a CEO of the company. The liquidator is required to select the details of CEO of the company while filing the form. So that is the thing when it comes to intimating the registrar and taking the facts of commencement of voluntary liquidation in the records of the registrar. Then commences the registered office of the company. Question arises as to, say suppose a voluntary liquidation process commences. After that, can a company change its registered office? there's no bar in changing the registered office of the company. Of course, there may be a situation, say suppose the company's registered office is situated in such a place where the company is paying high maintenance charges, or the charges that the company's rent the company is paying is quite higher, and the company is in a process to close its affairs. So it is very evident, is very natural that the company may shift the register office of the company. So that shifting of register office can also take place after the voluntary liquidation process commences. Discharge of the employees, since there will be no business exist after the commencement of voluntary liquidation process, so the offices of the employees will automatically stands discharged. Interest on debts, consolidation of suits, and further claims of the creditor, I'll discuss this in the later part of the session. So coming to the detailed procedure, as already mentioned, the valuations required to be done at the time of making the declaration of solvency. And in case liquidators finds that there is substantial difference between the value which has been initially estimated and the disposal price, in that case, he may also conduct the valuation, or he may also engage the registered valuer of the company for valuation of the assets. One thing that I just forgot to mention, that at the time of passing the special resolution, one should also take consent from the contributories of the company regarding mode of disposal of the assets of the company. Because unlike the normal liquidation, the provision for voluntary liquidation process says that the mode of disposal, mode and manner of realization of the assets should be as per the consent given by the corporate person. So at the time of passing of the resolution for the commencement of voluntary liquidation process under regulation 31, one should also the shareholders should also provide the manner in which the assets of the company, if at all there are assets in the company, how those assets will be realized. So public announcement, as I said, is required to be made within 5 days of appointment, has to be made in 1 English and 1 vernacular newspapers, should be uploaded in the website of the corporate person, if any, and should be given to the IBBI so that the same can be uploaded at the website of the IBBI as well. Now coming to the preliminary report. So there are basically 4 reports that the liquidator is required to be submit during the voluntary liquidation process. What are those reports? First is prelim report. Prelim report is about the prelim observations done by the liquidator after his appointment. So it is required to be submitted within 45 days of commencement of the voluntary liquidation process. What are the contents of this preliminary report? The contents of this report will be the capital structure of the company, the estimate of assets and liabilities, what are realizable assets, what are not unrealizable assets, what is the position of the company, how much assets are realizable, which all assets are there but are not cannot be realized, and the future course of action that the liquidator is thinking to proceed ahead with when it comes to the towards the voluntary liquidation process of the company. Now coming to as I said, the content of the preliminary report, whom to submit this preliminary report, because in liquidation the preliminary report is required to be submitted to the NCLT. However, when it comes to preliminary report during the voluntary liquidation process, this report is to be submitted to the contributories of the company only. However, the timeline is there. Timeline is 45 days from the commencement of liquidation process, liquidation commencement date. Now, classification of creditors versus claim. So in voluntary liquidation process as well, the creditors are required to submit their claim. Forms are provided. For operational creditor, form B is there. For financial creditor, form C is there. For workmen and employees of the company, form D is there. The entire form, what will be the contents of the form, are clearly provided in the voluntary liquidation regulation itself. However, the liquidator has to be very cautious while admitting the claim, while verifying the claim, because that claim, the verification will be based not only on the books and records of the company, but also based on the documents provided by the respective creditor to substantiate their claim. And proof of claim has to be borne by the respective creditors who are submitting their claim. When it comes to voluntary liquidation process, we are saying, as an example, we can say that there's enough food in the table. So when I'm saying that enough food in the table, so there is no question of priority as to whom will serve first, whom will serve second. But still in that position as well, section 53 is there in voluntary liquidation process as well. As it says that even if there are sufficient food in the table, who should, the priority should be there to avoid that that mara-mari between the creditors of the company. So this forms, based on these respective forms, the operational creditors, the financial creditors will submit their claim to the liquidator. Liquidators given a timeline within which the liquidator is required to verify the claim and prepare a list of stakeholders. So this list of stakeholders is not for constituting any committee, that no committee is required to be constituted. However, if liquidator wants, liquidator can hold the meeting of the contributories of the company in order to take their approval for certain things or to discuss certain things with them, and is also required to minutize the particular discussion and keep a record of that as well. Now, basis of proof of existence of claim of security interests. Usually these are not cases when it comes to voluntary liquidation process. However, there may be a situation that there are financial creditors having security interests. So section 52 is still there. Relinquishment of security interest is still there. The realization, the liquidator will be required to realize the assets, if at all there are any such assets in the company, and has to verify the claims given by the respective financial creditors, if at all in the process there are such financial creditors in the company. Now, determining the amount of claim and cost of claim. As I said, the cost of claim has to be borne by the respective creditors who are filing the claim. One has to be very cautious when it comes to verification of the claim, as maybe once you reject the claim, the respective creditor has a right to approach to the NCLT against the decision taken by you. Even though you have not approached the NCLT, the respective creditors may approach the NCLT against the decision taken by you under section 42 of the code. Now, list of stakeholders, as I said, within 45 days of acceptance of claim, the last date as mentioned in the public announcement, the liquidator is required to prepare a list of stakeholders, and in case there are no claims, in that case as well, the liquidator is required to prepare the list that is required to be prepared within 15 days. The timeline has been shrinked by the IBBI in order to expedite the voluntary liquidation process when there is nothing much to do by the liquidator. The list can be modified from time to time. This list should be available for inspection by the claimants, by the members, partners, directors, or guarantors of the corporate person, should be displayed on the website of the corporate person, and should also be there on the website of the IBBI. So once you prepare the list of stakeholders, you are required to give a copy of that list of stakeholders to the IBBI, and also required to make whenever you are making any modification in that list, you are required to submit that modified list as well to the IBBI. Then what should be the content of the list? The content of the list should be amount accepted, extent to which the amount is secured or unsecured, details of the respective stakeholders, and the proof what have been submitted, whatever proof has been submitted by the respective creditors in order to substantiate his or her claim. Now, coming to the liquidation cost, what all includes in the liquidation cost? First of all, of course, the remuneration, the fee of the liquidator is a part of liquidation cost. Remuneration of the professionals engaged by the liquidator, if any. What professionals liquidator is required to be engaged? Of course, the auditor. As a liquidator, the receipts and payments account to be prepared by the liquidator has to be audited. So liquidator is required to appoint an auditor for auditing its receipts and payments account. One liability is also there on the liquidator, which says that if the accounts of the company are not updated as on the liquidation commencement date, then liquidator is also required to get it up to date. So in that case as well, for auditing the accounts of the company, if say suppose the accounts of the company are not updated, the liquidator is required to appoint an auditor to get it updated and get it audited as on the date of liquidation commencement date. Now, cost incurred by the liquidator for verification or determination of claim, if any. So that cost will also be there in the liquidation cost of public announcement, that will be there, and the routine cost such as say suppose rent of the register office, salaries and wages of the employees, if at all the liquidator is required to make payment towards any. So those will also form part of the liquidation cost itself. Now, what will not be included in the liquidation cost? So any amount towards any loss, including any penalty, incurred on account of non-compliance of any provision of law applicable on the corporate person while conducting the process, so that will not be included in the liquidation cost. This is included in the this provision is there in the IBBI IP regulation, regulation 27B, which says that if at all there is any penalty applied on the company by virtue of non-compliance of any provision whichever is applicable on the corporate person, in that case the amount to be paid has to be paid by the liquidator from his pocket, and that will not form part of the liquidation cost. So one has to be very, very cautious when it comes to liquidation process, when it comes to taking up an assignment as a liquidator under voluntary liquidation. Powers and duties of liquidator, section 35 of the code, as is applicable in case of normal liquidation, is also applicable in case of voluntary liquidation. So this section empowers the liquidator to verify the claim, to take into the custody all the assets, all the properties, all the actionable claim whatsoever are there in the name of the corporate person, and to evaluate the assets property of the company, to make necessary measures to protect or preserve the assets of the company, if at all there are any such assets, to carry on the business of the company to the extent is required, to draw or accept any negotiable instruments that negotiable instruments or the checks, etc., has to be drawn from the liquidation account, which has to be separately opened by the liquidator once the liquidation commences. So that liquidation account has to be opened in the scheduled bank. And say suppose the company has 3-4 bank accounts at the time of commencement of liquidation, and there are balances available in all those accounts. So what will happen to those balance? All those balance are required to be transferred to the liquidation account, and those accounts are required to be closed at the time of commencement of voluntary liquidation process. And entire money, entire receipts, entire payments, whatsoever will be done during the process has to be done from that liquidation account only. And the liquidator is required to have the entire vouchers, entire details of the payment made or received from that account, and has to be very, very cautious while preparing this voluntary liquidation account, as this account is also required to be audited by the auditor, and then ultimately is required to be submitted to the NCLT and IBBI at the time of conclusion of the process. Apart from that, if the liquidator is also required to obtain any professional assistance, if at all he thinks that any professional assistance is required during discharging his duties, so that power is also there with the liquidator. Liquidator can have assistance or can have professional assistance if he requires any professional assistance during the discharge of his duties. It has powers such as it has powers to invite or settle the claims of the creditors and claimant, and distribute the realized proceeds in the manner as provided in the code, which is section 53 of the code. Apart from that, there are other powers as well of the liquidator, just such as power to apply to the NCLT for seeking necessary direction. What direction liquidator may require during the voluntary liquidation process? Say suppose after commencement of the voluntary liquidation process, the liquidator thinks that the company or the balance sheet of the company or the financial of the company, the liquidator thinks that the assets of the company are not sufficient, or the company will not be able to make payment of its liabilities. In that case, liquidator may apply to the NCLT for closing the voluntary liquidation process and dragging the company towards a normal liquidation process rather than this voluntary liquidation process. Liquidator has power to consult the stakeholders as and when requires. So there is no particular committee which is required to be formed when it comes to voluntary liquidation process, unlike the normal liquidation process. However, consultation power is still there, as and when the liquidator requires any consultation from the contributories of the company or the stakeholders of the company, it may take the necessary consultation and is required to monetize the same as well. Now, appointment of professionals. As I said, the liquidator has a power to appoint the professionals while drafting the resolution. This part should, the resolution for commencement of voluntary liquidation, one should also include this part as well, giving the power to the liquidator. While the power is already there in section 35, however, still the resolution should contain this part as well, that the liquidator can appoint the necessary professional and decide the terms and conditions of the appointment of that the respective professional. The fees of the respective professional that the liquidator is appointing has to be reasonable, and the liquidators also be cautious while appointing the professional that the person should not be a relative of the liquidator, should not be a related party to the corporate person, or the person who has served the company already as an auditor of the company in the previous 5 years, so that those persons should not be appointed as a professionals during the liquidation process by the liquidator. Now coming to reporting and record keeping. So during the process, there can be two types of documents. One document that the liquidator is preparing, one document which are related to the companies. Company related documents could be registers, documents prepared by the company. Liquidation related documents are the documents which liquidator prepares during the liquidation process, such as preliminary report, the declaration of solvency which has been given to the liquidator, then as annual status report if in a situation the company the liquidation process of the company is dragging beyond 1 year. In that case, that annual status report, the consultation if any the liquidator has taken during the liquidation process with the contributories of the company, or any professional advice the liquidator has taken during the process. So those documents the liquidator is required to keep, they're required to maintain. So there are timelines which are provided in the voluntary liquidation regulation itself, which says that the physical copy of the documents are required to be maintained for 3 years after dissolution of the company, and electronic copy of the documents are required for the period up to 8 years for from the dissolution of the company. So there are the details that the liquidator is required to maintain is mentioned in the slide. Liquidator shall preserve copy of the records relating to his appointment, relating to handing over, takeover of the assignment. Say suppose the liquidator is being appointed by the company, and after some time the company thinks that this particular liquidator is not discharging his duty optically, and accordingly intends to appoint some other liquidator to carry on the functions. So till that time, that period the person has acted as a liquidator of the company. For that period as well, the particular person will be liable for the documentation, is required to maintain those those documents for the period as mentioned in the voluntary liquidation regulation, and also required to hand over the entire documents to the prospective liquidator who will take over the process after in terms of the resolution passed by the shareholders. So appointment of new liquidator is in the hand of the shareholders. If the shareholders thinks, if the stakeholder contributors think that the particular liquidator is discharging his duty is required to be changed, the by way of passing of the resolution in terms of section 59(3), the corporate person, the contributories of the company may do so. Now coming to conduct of the liquidation process. So when it comes to liquidation process, I have started the liquidation process. I have given the newspaper advertisement inviting claim. I have asked the respective stakeholders to submit their claim. I have verified the claim. I have prepared the list of stakeholders. So I have a chart to whom I have to pay. But what I'll pay, now this question comes. So what I'll pay comes, it depends upon the realization of the assets of the company. So based on the statement of assets and liabilities given by the directors of the company at the time of commencement of liquidation process, I determine as to what all assets are there which are required to be realized. If at all there are any assets which are required to be realized, or the assets are readily available. So suppose the company has nothing but only balance in bank, so I am not required to realize anything. However, there may be a situation when there are income tax refund pending for the previous years, or there may be a situation like there may be a security deposit with NSE or other regulatory authorities, which after a certain time the company will get. So there are certain provision with respect to that. So to realize those assets such that you will create a fund, liquidation estate, and then you will make payment, make distribution. If there is a hierarchy that you have prepared, you have to make payment in terms of the hierarchy as per section 53. If there is no hierarchy as such, means there are no creditors as such who are required to be paid. In that situation, the payment, the amount which are there, the liquidation state that liquidator has created is required to be distributed among the stakeholders, the contributors, the shareholders of the company in proportion to their contribution, and also in proportion to their contribution, and is required to, the liquidator is required to make payment towards the entire amount which has been realized to the stakeholders, to the contributors of the company in terms of the contribution made by them. Now, bank account, as I already said, the liquidator is required to open a bank account in a scheduled bank. The regulation says that the liquidation account opened by the liquidator should followed by the word involuntary liquidation. Many a times liquidator faces this problem as well when it comes to opening such an account with the bank. Bank asks for numerous papers, but when there is a board resolution specifically specifying the same, these hurdles can be removed. So that is why I said that one has to be cautious during these documentation part prior to the commencement of the process, as the liquidation process becomes smoother when the documentation are proper. So whatsoever realization, whatsoever payments to be made has to be made from this account only. And if there are payment above 5,000 rupees, that has to be made only via check or via online. Distribution of assets, order of priority, as I said, first the liquidation cost, which includes fees of liquidator, fees of professional appointed by the person, fees of the newspaper advertisement cost that has been borne by the liquidator, auditors fees, etc. These are liquidation costs that has to be deducted. After deducting this liquidation cost, if the hierarchy is there, if there are creditors in the company, then in terms of the hierarchy, if there are no creditors, then the surplus money has to be paid to the respective contributories of the company in terms of the contribution made by them. Now, timeline for completion of the liquidation process. As I said, there is a recent changes in the liquidation process, which says that if there are no creditors in the company, then within 90 days, the liquidator shall endeavor to complete the liquidation process. However, if there are creditors in the company, then the timeline is 270 days within which the liquidator shall endeavor to complete the process. However, of course, based on the circumstances, based on the situation, this timeline may stretch. If the timeline is getting stretched, then the liquidator is required to take consent of the contributories within 15 days from the end of 12 months every year until the dissolution of the company to continue with the liquidation process. And at that time, the liquidator is required to submit the annual status report. I have already given a brief about the contents of annual status report as to what all should be there in the annual status report. The settlement of list of creditors, how many creditors have been paid, how the assets have been realized, what all assets are pending to be realized, what are unsold assets, if at all the liquidator is thinking of an in-kind distribution, if there are some certain assets which will be realized, due to which the liquidation process is stuck. So details of those things should be there in the annual status report, and that should all the audited accounts of the company for the entire year from the commencement of liquidation till that time should also be enclosed with the annual status report. Now coming to this final report part. So once the liquidation process completes, at that time, the liquidator is required to submit final report along with Form H. Form H is a kind of compliance certificate given by the liquidator that the liquidator has complied with the respective timeline given in the liquidation regulations, and these reports should be annexed with the dissolution application. Now the role of NCLT comes into the picture. So this final report is a conclusive document which includes entire documentation, entire things, entire details of the process so far done by the liquidator. The manner of realization of assets, the manner of distribution of assets, details of necessary resolution pass, if valuer appointed, detail of those valuers, everything, all the entire process, entire documentation that has been done since the commencement till the end of the process has to be there, should form part of the final report of the company, such that at the time of hearing, during the hearing, while presenting the case before the NCLT, the respective professional should be able to show the respective documents, the respective file, the respective accounts that the NCLT may ask for at the time of ordering the company as dissolved.
Barsha, may I suggest?
Yes, sir.
At this stage, take some questions as well, because there are some questions already on the chat.
Yes,
and people might have other questions as well. So I suggest maybe take some questions at this stage. Do you
sure,
think
sir.
logical
So
then should take questions? Right?
So I'll request the participants to kindly unmute themselves and ask questions.
There are two questions on the chat, if you can maybe see that.
Yes, sir. Yes, sir. So I think the first question is from Shubham Gupta. The question is, can this consent be taken post the liquidation commencement date? Consent from stakeholders with respect to the manner of disposal of assets. This consent can be taken post the liquidation commencement, post the liquidation commencement date as well, but the consent has to be taken. So what we suggest is, when the company is deciding, when the contributories are deciding to liquidate the company, at the very moment if a consent has been taken, then the liquidator is not required to hold the meeting of the contributories. Say suppose there is only one contributory of the company, and the company decides that the respective WOS or the subsidiary of the company should dissolve. In that situation, the consent of the stakeholders, the consent of the contributors should be taken under Regulation 31 as to in what manner the assets of the company, if at all there are assets in the company which requires realization, should be realized. That should be the ideal position. However, yes, the consent can be taken at the later stage as well, because Regulation 31 does not say that this consent should be taken at the time of commencement of liquidation only.
To my mind, we'll also have to go by analyzing the number of contributories.
Yes.
If the numbers are large, let's say there are 500 contributors, not getting a concurrence from such a large number of stakeholders, Kairav, Trivedi ji and others, you might even like to raise hands and speak if you think that's a better way, instead of taking time to write on chat. Whichever way you think appropriate, we are okay. So I was saying, if the number of contributors is large, and then calling meetings of contributors and taking their concurrence later on would be quite cumbersome and unwieldy process. So in order to facilitate any such stakeholder consent, which to my mind, there might be several occasions when consents are needed. Things are much easier if you have just one holding company, couple of shareholders, that's it. Things are much easier in that case. A family of shareholders, very easy. But if there are diverse shareholders, I would think it might even make sense to have a stakeholder committee. Like we have stakeholders committee in compulsory liquidation, to constitute a stakeholder committee at the time of commencement itself, which is empowered to grant such take decisions on behalf of stakeholders later on, because there are, it's a, you never know, there might be things which might require reaching out to stakeholders again. So instead of depending on a diverse body of stakeholders to give concurrence later, it might make sense to have a smaller advisory body or stakeholder consultation committee kind of a thing to give consents. There's some further question which
yes,
Barsha,
the next question is, in case of non-operating corporate debtor, all assets sold before CIRP, can early dissolution be applied to NCLT? I think this question pertains to liquidation process and not the voluntary liquidation process, because it says CIRP. So if, say, suppose during CIRP process only, in case of non-operating corporate debtor, all assets sold before CIRP. So in CIRP, there will be no question of selling the assets. There will be a resolution plan submitted by the prospective resolution applicant. So, sir, if you can kindly clarify your query once.
I think what Mr. Kara might be wanting to say is that if there are either, it's a non-operating company, the assets may not be there. There may not be much assets to dispose of. And there may not be resolution applicant. There's nothing to resolve. It's a gone case. It's a sunk company already. But it was a case of insolvent liquidation, where by virtue of law, we'll first have to go for resolution before we go for liquidation. So in such cases, maybe at the very first meeting of the so-called COC, you pass a resolution for liquidation right away. You can go for early liquidation by passing resolution. I think now they are probably inserting a provision in IBC to not necessarily go for resolution first. You can go for liquidation straight away. But otherwise, you can do it with the concurrence of creditors, the very first meeting.
Okay, sir. Okay.
Mr. Kairav Trivedi, I hope the question is taken care of. If not, kindly speak on.
So next question is there. It says that in voluntary liquidation for 2 shares, I could not get the FCTRS compounded, while it did not rest 99.99%. As I can't repatriate, can I transfer the funds to IPF and explain to NCLT? So this is, I believe, is the amount which could not be repatriated to the foreign shareholders of the company, and accordingly is left with the liquidation account. Am I correct?
Yes, that's what it means.
So in that case, if the fund is, I think this is, if the fund is there in the liquidation account which belongs to a certain creditor and merely could not be transferred due to repatriation issues, that amount should not go to the undistributed or unrealized proceeds. However, the measure should be taken to distribute the amount or to make payment to the local account of the company, if at all that is possible, rather than transferring the amount to the IPF. That is basically for the unclaimed or undistributed amounts. I suppose there are the amount is there and there is no one to claim for that amount. In that case, the amount, the liquidator is required to transfer that particular amount to the company's voluntary liquidation account. And if at all tomorrow any of the creditor comes and claims that this particular amount is mine, in that situation, the IBB is required to distribute the amount after verifying the details of the creditors. So correct me if I'm wrong in this, if answering.
No, I
this
think one has to take a practical view here, because the query is saying that there was a FCTRS pendency which was not taken care of and matter has not been compounded. So the transfer cannot be done. In many cases for non-filing of forms, authorized dealers don't allow the remittance to happen. Barsha, you would agree that you would also long face that the long trail of
Yes, sir.
pursuit with authorized dealer, after which, I mean, a long persuasion, the money could be remitted overseas. So this is something that practically happens. Now we're talking about only 2 shares or 2 shareholders. The small amount. I think the one has to take a practical look. How can I allow the entire proceeding to drag on just because I've not been able to remit to 2 shareholders? Well, if it's a FAMA pendency which couldn't be corrected, liquidator is not to be faulted for that, because it's a continuing obligation of the company. I would think, based on totality of the facts, one could take a view that it's a case of not being able to distribute money. Transfer it to IPF, as and when the foreign shareholder wants to claim it, let him claim from IPF. Transferring money to IPF doesn't mean the claim is gone. The claim is still there. You need to claim it from IPF. Let them claim. I
Yes.
would have done that. I mean, with small amount, I would have just, I mean, that I think seems to be practically doable. Shubham Gupta ji is raised hand, but if there are other questions, you can see. He's saying, I will even get the NOC from shareholder. Please go ahead and do. Shareholder himself will agree, मेरा पैसा डाल दो IPF में, because the money is, you need to proportionality of the money. How much is the stake and how much is the pain in getting the compounding done? Mr. Shubham Gupta.
Hello, sir. So I have a question regarding distribution of money only. So let's say if there is a case wherein there are a couple of litigations going on, which happens precisely the tax litigations are going on, which are form of a contingent liability in the company. And the liquidator is very much mindful of the fact that as per November 2021 a notification from IBBI that NOC from income tax department is precisely not required in case of voluntary liquidation. So do you think he should wait till the time that all these litigations are closed, and then only the amount which is lying in the bank account of the company can be remitted to the shareholders, or he can go ahead, remit the money, close the bank account, and submit the final application with the NCLT, only for the fact that because of the fact that NOC was not required, and at the same time the tax authority has not filed any claim when the newspaper advertisement and everything was done at the time of commencement of liquidation.
Sir, if I answer this query. So, so if you see provision of section 178 of Income Tax Act, it requires the liquidator to give intimation to the income tax department or the respective assessing officer under whose jurisdiction the company falls within 30 days of commencement of voluntary liquidation process to intimate regarding the liquidation process. And after sending that notice, 3 months timeline has been given to the assessing officer, to the commissioner of the income tax department to come back with the amount which is required to be set aside to meet the obligation towards the income tax liability. So we are of the view that after waiting for the 3 months, if say suppose no communication has been received from the respective assessing officer, after waiting for 3 months, the liquidator may proceed ahead with passing of the transferring of the money or with the payment of the amount to the in terms of section 53. As you rightly mentioned, this requirement of seeking specific NOC from the income tax department is not there. It has been removed via IBBI's notification dated 15th of November.
Right. So practically, just in case if you have dealt with such cases wherein you would have filed an application, because my apprehension in this particular case would be that when the application would be filed with the NCLT, NCLT will definitely come back and say in the balance sheet there has been a couple of tax litigations wherein some amount was required to be paid or was contested by the tax authorities, and considering the fact that they had not filed this application, or they might ask to send a notice again, or they might ask the representative of the tax department. uh, have you done is there any practical experience around it, how to
Yes,
deal with such situation?
I'll just brief regarding that, sir. So there have been cases that we have dealt in the past wherein we have filed dissolution application with the NCLT, and we have not obtained the specific NOC from the income tax department. However, we sent the notice. We had sent the notice in terms of section 178. However, we haven't received any specific NOC from the income tax department. So once you file the dissolution application, at the time of hearing, NCLT asks the registry or directs the registry to serve a notice to the income tax department to respond with their demand, if any, within 30 days of time. So this is not there specific in the regulation. However, the process to be followed by the respective NCLT. Now the process also differs from NCLT to NCLT because some NCLT relies upon this IBBI circular that no specific NOC is required when you have given notice under section 178. However, some registry like NCLT Mumbai specifically requires to give a notice to the income tax department, asking them to revert with their concerns, if any.
They're not waiting for the NOC. It's a question of giving a notice. Let the 30-day notice be given if you want to present yourself and say, I have a claim.
Yes.
But quite likely the tax department will stand up and say that I have a claim. The claim is not still determined. See, section 178 does not say that the time for determination, because section 178 gives the time to principal commissioner to set aside an amount sufficient to meet the tax liability. You would probably say, okay, there's demand and contingency, there's demand waiting to be decided, so set aside the money. Suppose say let the estimated amount could probably be, let's say 1 crore. Set aside, keep the money. I'm not stopping you from paying money to creditors, settle your liabilities. I am only stopping you from distributing money to shareholders. The money should not disappear into thin air so as not to be recoverable at all. So given the fact that it's not a case of section 53 priorities where secured creditors need to be paid first, etc., we're talking about payment to shareholders, which in terms of section 53 as well comes as the last in the list of priorities. So if the tax department comes with a claim even before dissolution order is made, will the NCLT not give them a time to file the claim? They'll definitely give them a time. And then you have to admit the claim. Once you admit the claim, the money will become payable. So I don't think it would be a good practice. If you, well, of course, depends on how substantive the matter is. What's your view on the, I mean, the liability in question? But since it's a case of voluntary liquidation and it's not a case of section 53 priorities, I would suggest take a practical view. You can probably expedite the matter, bring it. These days, it's not like matters run for years and years. You can settle the matter sooner. You can probably go for some kind of a Vivad se Samadhan type kind of a scheme and maybe try to bring it to a conclusion.
So just one point on that.
As simple as that, Vivad mein nahi jaake Samadhan mein jaiye, seedhi baat hai.
Understood, sir. Just one particular point here. Let's say we have gone ahead and we have served notices, everything. But when NCLT serves a notice, at that point in time, I have already distributed the cash. I have already closed the bank account, and after
that, I think normally we do after getting the NCLT's orders. Typically, what we do, and that's what I think my colleague will also recommend, that before we go to the final step of final distribution, closure of account, we should actually go to NCLT and say, now I'm doing that. So give me 5 days time, 7 days time to close the bank account, do a final distribution, and then we come for dissolution order. I mean, final distribution, closure of account, my recommendation is do after making application to NCLT.
But then under what section you will apply to NCLT? Because under voluntary liquidation, you will only go to NCLT once everything, the liquidator has closed the bank account, distributed all the assets, then only an application will be made to the
Barsha,
NCLT.
you can maybe answer this.
If you can see the voluntary liquidation regulation, it does not specifically mention that you have to close the liquidation account and require and attach the proof of closure of liquidation account with the dissolution application. So what normally happens, practically happens, is you file the application with the NCLT for dissolution of the company, attach the entire details of the process via Form H and final report. And in the first hearing, you seek direction from the NCLT towards closure of this account, this liquidation account, such that the remaining balance whatsoever is there can be distributed to the respective entitlees of that amount, and accordingly the affidavit with respect to closure of this account can be filed with the NCLT.
Okay, understood.
Mr. Ravi Bagri and then maybe Vinod Kumar ji. Ravi ji.
Sir, I am Vinod.
Yes, Vinod Kumar ji.
Sir, my question is that, say, during the process of voluntary liquidation, the liquidator is of the opinion that the voluntary liquidation is not possible for some reasons. How to restore the company, that is the corporate debtor, to its original position? Because we have already intimated to the ROC, and then accordingly ROC in the master data has shown that it is under liquidation.
So the way, sir, you have intimated the ROC that the company's voluntary liquidation process commences, on the very same way you are required to intimate to the registrar. So before intimating the registrar, you are required to make an application to the NCLT saying the reason as to why this voluntary liquidation process is not being carried on, and accordingly for allowing the company to go for the liquidation instead of this voluntary liquidation process. And once you receive the order, a copy of order should be communicated to the ROC to take necessary action and make necessary changes in the MCA portal.
Ma'am, under which section we shall make an application to the NCLT? Is it Rule 11 only?
Yes, sir, Rule 11 only.
Thank you very much. Thank you.
Is there any other question?
There was somebody raising hand, but I think it's lowered already. So maybe I think you can continue.
Right. So now coming to the treatment of unclaimed and undistributed amount. When I say unclaimed or undistributed amount, as we have taken some questions recently, that there may be creditors, there may be stakeholders of the company who have not claimed the amount, who are not traceable. There can be situation in case of large company, listed companies or so, that there are creditors, benami shareholders who are not traceable. So what will happen to the proceeds of those shareholders? So the liquidator is required to make distribution as per 53, whatsoever the respective entitlements of the respective shareholders will be. After making the distribution towards the corresponding account, to the corresponding account of the respective shareholders who are traceable, the balance amount has to be transferred to the corporate voluntary liquidation fund account. This account is maintained by IBBI, and IBBI after 15 years will transfer this amount to the government's fund. So this is the process of treating the unclaimed or undistributed amount. There can be assets which cannot be distributed. There can, or in-kind distribution of the assets is also not permissible. There can be a situation to that. But liquidator, again, here comes the caution that liquidator has to be very cautious about this transferring of the amount, because if the amount is not being transferred within the given timeline, it's provided under the voluntary liquidation regulations, then the liquidator will be liable to pay interest thereon at the rate of 12% per annum. And along with interest, the amount has to be transferred to that corporate voluntary liquidation account. Suspension of the process, as I said, that if during the process the liquidator realizes that the company is not solvent, or the company will not be able to make payment towards the liabilities, some past liabilities, some income tax liabilities, or some other kind of liability are there, which due to which the company will not be able to make payments towards its dues. In that case, the liquidator can apply to the NCLT for liquidation process to be carried on instead of the voluntary liquidation process, or suspension of this voluntary liquidation process. Now, tax implication. Tax implication part, Mr. Kothari has already discussed in brief, so I'll just give a bit detail about this process, that when it comes to distribution during the voluntary liquidation process, the amount which has been distributed, to the extent that amount pertains to the accumulated profit, that amount will be treated as dividend, and accordingly will be taxable in the hand of the shareholders. Then again, section 46(2) is there, which is about the capital gain payable on the consideration received. This consideration amount will be reduced by the amount of accumulated profit or the dividend part under section 222C, and the balance amount will be taxable in the hand of shareholders. When it comes to taxable in the hand of the company survives till the dissolution. And so the company is required to make payment towards the income tax liability till that day. What income tax liability could arise after the company has gone into voluntary liquidation process? There may be interest income that the amount is sufficient, the huge amount is there in the bank, and the company, the liquidators has kept the amount in the fixed deposit and has earned income during the voluntary liquidation process. Or say suppose there were income tax refund pending for the previous years, and the income tax department has refunded the amount along with the interest component. So that particular interest component of that income tax refund part will be treated as the income and accordingly will be chargeable to tax. So all the tax till the date of filing of the dissolution application has to be borne by the liquidator from the liquidation state as are applicable on the company. And section 178, as I already mentioned, that 178's notice is very, very relevant, that liquidator is required to give this notice within 30 days of commencement of the liquidation process to the assessing officer, intimating the assessing officer that this company has gone into liquidation and I am appointed as a liquidator of this company. Whatsoever communication with respect to the outstanding demands are there can be made in this particular ID. Details of the ID, details of the communication address of the liquidator can be provided in that communication mail or the letter that the liquidator will submit to the respective income tax department. And there will be a time, there is a timeline provided in section 178 which says that within 3 months the respective income tax department, the assessing officer or the ACIT will come up with the amount which the liquidator is required to set aside towards the income tax obligation, or may come up with the amount which will be sufficient to make the income tax liabilities, to meet the income tax liabilities of the company. Recent amendments, as I said, one amendment was there in case of declaration by the director, which says that the provision as to how the records will be preserved after the closure of the process, that should be there, that should form part of the declaration of solvency itself. Earlier, the liquidators were required to make provision, liquidators were required to make some arrangements such that the records of the company can be kept for the given period, as liquidation regulation requires, the voluntary liquidation regulation requires the liquidator to keep the physical copy for 3 years. So arrangements such that those physical copies can be properly maintained and can be provided for, if at all in future asked by any particular authority, can be appropriately provided for. So the liquidators was required to maintain do these arrangements earlier. Now the directors of the companies are responsible. They are required to provide as to in what manner and how the records of the company will be preserved. There can be minutes book, there can be registers of the company. So how those documents will be preserved. So these details should form part of the declaration of solvency itself. Now, as per the recent amendments made, preservation of records. As I said, the regulation requires us to for what time the liquidator is required to keep the records of the company. 8 years and 3 years, 8-year e-copy and 3 years for the physical copies of the company. Now coming to the practical queries, some of the practical issues that the liquidators might come across during discharging their duties as a liquidator, that some of based on our practical experience as well, we have jotted down the queries on the practical issues. So Regulation 31 of the liquidation regulation provides that liquidator may sell assets in such manner and mode as may be permitted by the corporate person. So yes, this regulation was there earlier as well. This specifically requires that at the time of while deciding the manner of disposing of or realizing the assets of the company, under this particular regulation, under voluntary liquidation regulation, the consent of corporate person is required to be obtained. The corporate person is required to decide, is required to approve as to in what manner the particular assets of the company will be realized. So ideally, if the company is not a huge company, if the company is a huge company, in that situation, it is advisable to take the consent at the time of commencement of liquidation itself, rather than holding the meeting of the contributories again and again. It's better to take the consent at the time of commencement of liquidation itself. Then transparency of selling of the process is important. The liquidator is accountable for each and every shortfall. If at all there is any shortfall, then for that liquidator will be accountable. And not only shortfall, as I already mentioned, as per the IP regulations, if at all there is any penalty on any of the non-compliances non-compliances of any of the provisions, any of the law applicable on the corporate debtor, then liquidator is accountable for that too. So liquidator has to be cautious about this as well, and has to be transparent about the shortfall, if any, in the liquidation proceeds in the liquidation account of the company. Can liquidator distribute assets in kind? Yes, it is permitted. Liquidator can distribute the assets in kind. However, approval from the members is required to be obtained in that case. What will be the fate of subsidiary company whose holding company has filed for liquidation regulation? Now, say suppose the holding company is going for the liquidation and I am the wholly owned subsidiary of the company, then what will be my fate? Since the holding company holds the investment in the subsidiary company. So the assets of the subsidiary, the investment is basically the assets of the holding company. So subsidiary company will still survive even after the holding company is going for the voluntary liquidation process. What will the fate of guarantee provided by the corporate person? Mr. Kothari has already discussed this part. What will happen to the guarantee? Now coming to this next question, which is whether company under voluntary liquidation is required to file annual report, annual return. This also I have discussed in brief, that there is a MCA circular of 2020 which says that the liquidator is not required to file AOC 4 or MGT 7. This is required to be filed till CIRP process only. Now, IT return, what will happen to the IT return? Whether liquidator is required to file IT return? Of course, liquidator is required to file the IT return. Till the commencement of the date, the ex-director, the management of the company will file the IT return. Post commencement of the liquidation process, the liquidator is required to file the IT return. So necessary changes with respect to the signatories to be done at the RT portal, so that liquidator can file the income tax return. Then can dividend be declared by the company which is under liquidation? So there's no case of declaring the dividend. However, yes, if there is an accumulated profit of the company that the liquidator is distributing during the liquidation process, so the extent of distribution that forms part of the accumulated profit will be treated as dividend under section 220C of the Income Tax Act. Whether liquidator's account needs to be audited? Yes, mandatorily. Regulation 37 requires the liquidator to audit the accounts also at the time, if say suppose the liquidation process goes beyond the period of 1 year. In that case as well, it specifically requires that the annual status account should be accompanied by the audited accounts of liquidator, receipts and payments account of the liquidator. And of course, at the time of dissolution, the final report should be accompanied by the audited receipts and payments account. Is a no due certificate from income tax department is required to be submitted along with dissolution application? No, there is no such requirement of obtaining no due certificate from the income tax department. However, it is it will be favorable if you receive the income tax no due certificate from the income tax department while giving the notice under section 178. However, there is no compulsion. Even IBBI also clarifies by way of a notification dated 15th November 2021 that if you have given the letter in terms of section 178 to the income tax department, in that case the obtaining NOC from the income tax department is not required when it comes to voluntary liquidation process. Then presence of pref shareholders and debenture holders. If there are pref shareholders, there are debenture holders, what will be the fate of the pref shareholders and debenture holders? Debenture holders, of course, will be treated as a debt and accordingly will be paid. And the payment of pref shareholders will be, of course, on the preference. However, will be paid in terms of, via the surplus fund after making payments towards the debt of the company. If a company has multiple branches, then what is to be done? Branches, if those branches are on rent, then the rent agreement has to be called off, and then accordingly the liquidator has to close the respective branches which are not required to be carried on, and such that the wrapping up process can be continued, and accordingly details of the termination of the rental agreements etc. should form part of the final report or dissolution application the liquidator files with the NCLT. Terminal benefit of employees, of course, that are required to be paid as a date of commencement of liquidation process itself is a date of automatic termination of job of the employees of the company. So if there is a terminal benefit, there are gratuity payments, whatsoever claims of workmen have. Now, there can be situation when workmen do not file their claim with the company. In that situation, the regulation requires that as per the books and records of the company, the liquidator is required to admit the claim towards the workmen, if at all there are any workmen in a company. Normally, it doesn't happen in case of voluntary liquidation process. However, still, if at all any company has workmen, which so as per the books and records of the company, if the workmen have not filed their claim, then the liquidator is required to admit the claim as claims are there in the books and records of the company. Contingent liabilities and litigation value of such assets has to be crystallized so as to ascertain as to whether the declaration of solvency has been made by the directors of the company has been made correctly or not, and whether the assets available in the company are sufficient to meet those liabilities as well if say suppose arises tomorrow, so whether the company will be sufficient to make payment towards those liabilities or not. So this part has to be taken care of. Then role of directors and promoters to the extent required for the beneficial liquidation of the company should be there. In case there is any non-cooperation, regulation 19 is not applicable when it comes to voluntary liquidation process, because regulation 19 is there in case of liquidation. Normally in case of voluntary liquidation process, any kind of non-cooperation, any question of non-cooperation from directors or promoters does not arise at all. So when it comes to okay, next question is about proceeding from avoidance transaction application.
There are some hand raises, and plus maybe there might be other questions as well. So maybe take a little breather, get some questions. आप तो एकदम लगातार बोले जा रहे हैं.
Yes.
तो आप देखिए, एक शिवम गुप्ता जी ने हैंड रेज किया, कि कोई और को भी कोई जिज्ञासा हो तो
kindly unmute yourself and ask.
And आपका previous slide में maybe you're not fully covered still, so be there, but थोड़ा बीच में रुक के उनको थोड़ा मौका देते रहिए क्वेश्चन करने का.
No issues, sir. I'll request the respective participants to kindly unmute yourself because there are no questions in the chat box as I can see. So if you can kindly unmute yourself and ask questions.
So if I may ask one question here. So in your previous slide, you mentioned that AOC 4 and an MGT 7 is required to be filed along in GNL 2 by the liquidator. So I have a related question here. In one of your previous slides, you mentioned that the powers of the directors are suspended as soon as the liquidator is appointed, right? But
yes.
Under IBC, Section 17 deals with the suspension of the powers of the board, right? And under voluntary liquidation, Section 17 is not covered. It covers only 35 to 53.
Yes.
So it is nowhere under the Act which provides that the powers of the directors is suspended. That's my first summation. Now, relating to this, is there a requirement mandatorily, or can this be read as that the directors, even when the liquidator is there, are liable for the compliances under Companies Act, which requires them to file the director's report, to prepare the financial statement, to sign the financial statement for the period. Let's say, let's take an example that the shareholder resolution with respect to appointment of a liquidator was passed on 30th of April, right? And the past 31st of March has been was required to be audited because the company was up and running at that point in time. But from 30th April, the liquidator has taken charge of it. Now, what will happen with respect to the audit of accounts till 31st of March? Who will sign the balance sheets? Whether there is a requirement to file the director's report? Will that come on the directors that AOC 4 and MGT 7 needs to be filed in a manner that is as per normal companies, or liquidator will file these financial statements in GNL2? That's my question.
So as correctly mentioned by you, sir, that the provision of section 17 as is there in case of liquidation process is not there in voluntary liquidation process. In fact, the voluntary liquidation process says that company ceases to exist, the business of the company ceases to exist on the very moment the liquidation commences. So of course, when it comes to voluntary liquidation process, the directors are there. However, there's nothing to do when it comes to wrapping up the affairs of the company. So to the extent required, the liquidator can take assistance of the directors or promoters or KMPs of the company to the extent is required for filing, etc. That is my view. When it comes to filing to be done with the respective department with the MCA with respect to AOC 4 and MGT 7 as you mentioned. So that MCA circular says that you are required to first file the GNL 2 form, and whatever attachments will be there, those AOC 4 and MGT 7 can form part of that GNL 2 as attachment. So practically that should be done, that if liquidator is there and if the liquidator is required is permitted to file the GNL 2, the respective forms. Say suppose the company commences, the voluntary liquidation process of the company commences on 18th of April or say 28th of April. However, the requirement of filing MGT7 till the previous years is still there for the last year. As of 31st March is still there. So what will happen to filing of AOC4 or MGT7 for that year? So either if the provisions are there that liquidator can be allowed to file these AOC4 and MGT7 as attachment to GNL2, liquidator can file the application, or liquidator can authorize the existing directors of the company to file the same on behalf of the company.
So, Barsha, my question here was: is there a mandatory requirement to hold a board meeting and AGM approve the financials in the board meeting? Basically, coming from where the powers and the duties of the board of directors has not been suspended in case of voluntary liquidation, and they were very well required under the Companies Act to act and in certain manner. These are the matters that needs to be approved by the board. So once on 30th of April, let's say that the liquidator has been appointed, and it takes time to do the audit. Let's say the audit gets completed in July or August. Then do you suggest that a proper board meeting should be held wherein the financial statement should be approved to be signed by the directors, and then subsequently do you suggest that AGM should be conducted wherein the accounts should be taken on record by the shareholders, and subsequently the compliances of AOC4 and MGT7? Although with respect to filing of AOC4 and MGT7, you have already clarified, considering the fact that there's a MCA clarification around it and you will be filing in GNL2. But the other procedures with respect to holding a board meeting and AGM, what's your view on that?
So, of course, filing with MCA is the secondary part. First part is towards the auditing the accounts of the company. So, at the time of commencement of voluntary liquidation process, the directors of the company are required to submit declaration of solvency, required to provide the statement of assets and liabilities. So, in my view, that at the time of providing or conducting or providing this declaration of solvency as well, the directors should rely upon the audited financials as on that date. How can they rely upon the draft financials as on date? So, and that should be accompanied by the audited financial statement of the past 2 years of the company from the liquidation commencement date. So as on 31st March, as it is my view that as of 31st March, audit should be done by the directors of the company who were there in the board. And once the process commences, after that, the requirement of director's report or audit report should not be there. I'll request sir to correct me if I'm wrong in this.
No, I think practically, if you think of a practical way to resolve it, when the shareholders are meeting, let's say on the 18th of April to pass a resolution, before that, maybe the board would have also met to give a declaration of solvency. And the board will also approve statement of assets and liabilities that's need to be given to the liquidator. The statement of assets and liabilities has to be given by the board to the liquidator, and the liquidator then prepares it basis the statement given by the board. So issue is that the financial statements as of 31st March preceding the commencement date would necessarily be authenticated by the directors. Now, taking it to shareholders may be redundant because by that time the liquidation would have commenced, and therefore authentication of accounts or placing the accounts for adoption by shareholders will be a redundant formality, but at least the authentication by the board of directors would definitely be there. So when we say directors automatically lose their power, because once liquidation commences, the company is into a winding up mode. Directors are required to direct the business of the company. We are not into a directional path now. Now we are into winding up path. There is absolutely no role for directors once the shareholders have passed a resolution for voluntary liquidation. Public notice has been given. That would mean the control of the company is now shifted from directors to the IP. So directors obviously don't have a role. However, if the IP so requires the directors to meet, they can do a meeting. Now, would we call it board meeting in terms of company? That's surely not. It's a meeting called at the instance of the IP. Directors present there, the directors authenticate. Maybe the CFO signs as well. Maybe the auditor sign basis that. So all that can be done at the background, and the IP can then attach those financials along with his GNL, whatever. So I think there's something we normally recommend, even if let's say liquidation commences, wasn't voluntary liquidation, say compulsory liquidation commences on a particular date. Would you be signing the financial statement? Surely not. Because you were not even there in the process. Similar CRP also, let's say technically directors are suspended, but who authenticates the accounts? For the part of the year before commencement of CRP, there is a statement of there's a financial statement to be approved. Who approves it? IP calls for a meeting. IP calls for a meeting, but directors come. They are not exercising directorial powers. They are doing it at the instance of the IP. So we normally say IP countersigns it, directors also sign it. So we need to actually, not absolving the directors of their duties completely. At the same time, not as exposing the IP to unwarranted, obligations for financial statements. We need to actually find a way out.
Also, sir, just one more question. Post commencement or post commencement of this voluntary liquidation, do the IP is required to maintain the accounts from 30 for the financial year ending 31st of March, or his financial year will start from his liquidation commencement date? That is, at the end of first year from the date of his appointment, he has to submit those receipt and payments account.
So obviously his liquidation commences from the date of passing, from the liquidation commencement date. Before that, it's still financial statements up to that date. So for the broken period, that is from 1st April till the liquidation commencement date, it would still be a financial statement as usual. Thereafter, it becomes receipts and payments account. Okay, if there is no further question, then Barsha, I think you can continue.
So I am now on conclusion part basically. So when it comes to dissolution of a company, we filed the application for dissolution with the NCLT. Hearings will take place. NCLT will go through with the respective documents, with the audited accounts, etc. And if finds that the liquidation process has been conducted in the manner as directed in the voluntary liquidation regulations, and if say suppose the consent has also been given by the income tax department, so in that case the NCLT will direct dissolution of the company, will order for the dissolution of the company, and the liquidator is required to communicate regarding this dissolution within 14 days of receipt of the order to the registrar of companies, and the dissolution order should also be uploaded on the respective website of the company and to intimated to the IBBI and other regulatory authorities as well. Now the question arises, if say suppose the company has been dissolved, can the dissolved company also be revived? So the provision regarding this was there in Companies Act 1956 under section 560, and the provision still there in Companies Act 2013 under section 252(3), that yes, a company once dissolved by the NCLT can also be revived. The timeline is 20 years from the name being struck off by the ROC after getting the intimation of the dissolution by the NCLT. Now, every case of dissolution leads to the name of company being struck off from the MCA portal, because the moment you intimate it's not being struck off, basically the status will show as dissolved in the MCA portal. Now coming to section 252(3), which says it ought to be applicable in case of dissolution under IBC as well, which is about the revival of the company. If there is some reason, the purpose of restoration is mainly to admit the claim that that may have been remained, or some distribution or some disputes whatsoever. So in that case, yes, a company can be revived. I think this is the last slide that I have. I'll request the participants to raise the concerns, to raise the questions. I'll try to answer the queries to the extent possible.
Barsha, I have a question on this particular slide itself.
Yes.
You are referring to section 252, which is under the provisions of strike off by ROC. But particularly in case of dissolution by NCLT, do you think 252 will be applicable for reviving it?
So process of revival can still be there. Say suppose the NCLT has dissolved the company. However, later on it found that the company was not, so some part was missing during the liquidation process, could not, and the say some department comes up with some queries, some entitlements, some proceeds which could have been distributed, however not distributed, a later part as well. So of course the process of revival is still there. That is based on rulings that we have found.
Okay, but I seriously doubt that, because in case of 248, wherein the strike off, that's my understanding here is, because in case of 248, wherein you are going for a strike off, You do not seek any NCLT approval there. You just file an application, ROC approves your case, or ROC
Because
suo motu
at
takes a
that time, sir,
decision.
you are required to provide nil assets and nil liability statement as well when it comes to
Right.
to application for strike off. So that
Right.
requires nil assets and nil liability statement. And when it comes to voluntary liquidation, you are closing the affairs, you are wrapping up the affairs, you are realizing assets, you are making distributions and preparing a report, submitting the report to the NCLT, and based on your report, the NCLT is passing the order for dissolution of the company.
Exactly my point. That
So
in the case of voluntary liquidation, we are seeking NCLT's approval for liquidation. But however, in the case of 248, wherein NCLT was not involved, that is why the power to restoration was given to NCLT. That if at all there has been a decision taken by ROC or RD, which in their your decision was not correct, and if some facts of the case brought later on to revive the company, then NCLT has been given power to revive. But wherein I have taken the same jurisdiction approval of the same jurisdiction and dissolved the company, how will it get revived? I seriously doubt that 252 will come into play
I'll
in
check
case
that
of
part once.
voluntary
I'll
liquidation.
check that. I understood the concerns. I'll check that part once.
Let me just also respond on that. During the winding up regime, now, first of all, region-wide restoration may still be needed. So Shubhamji and others, please realize that when we went for liquidation, whether voluntary or compulsory, there were some assets or some liabilities which were not known. And later, let's say after 5 years of dissolution, we come to notice that there was an asset in the name of the asset was not perhaps on record, the asset was not showing up on books of the company. However, the asset is found to be existing. There might sometimes these might be leasehold rights, because leasehold rights are typically not shown on the balance sheet, just a right of a lessee. But right of a lessee is also a very valuable right. Calcutta Port Trust, for example, had given leases for 99 years. The leases were not showing on the books of the company, but that's a very valuable right. So sometimes people detect that there were some hidden assets which were not showing, and therefore they might be interested to revive the company back. So question is revival of a company which has been dissolved completely by a process of winding up, is revival possible? There are plenty of cases of revival of companies after years of the winding up order being passed, dissolution order being passed by courts. There'll be a lot of instances in Calcutta High Court itself. Companies have been revived a long number of years. In one case, we had to write the books of the company for 6-7 years because revival happened 5-6 years after the company was dissolved. So that's practically being done. Now, there are two things in section 252. One is appeal against order of the ROC, where 20-year time is not. 20-year time is 252 by 3, which is anyone who's agreed by order. Anyone who's agreed by striking of action. Eventually, even if the company is dissolved, the name is struck off. Because live register of companies, the name gets struck off. It's no more a name on the register of companies. And therefore, that's a question of bringing the company back into existence. So process of revival does exist, even if not specifically handled by 252. I would say on just and equitable grounds, NCLT may still order revival of the company. That is, I would say, practical insight into, and I once again reiterate that plenty of cases of revival. You can probably just Google revival of companies by Calcutta High Court, you probably find at least 20-25 cases, years after winding up order has been done. But I think before participants have other questions, I would quickly maybe add a little perspective on the accounting. Accounting for voluntary liquidation by the corporate debtor itself. There's nothing much as to say, because liquidator himself will not be preparing financial statements as such. He'll just be preparing the receipts and payments account, and periodically.
Yes, sir. This is Shankar Panikar.
Just give me 2 minutes, sir. Just 2 minutes to finish your point. Shankar sir, just give me 2 minutes. So
yeah,
I was saying, not to be referring to the receipts and payments account of the liquidator, but the question is, what about the accounting by the shareholders during the period of, continuation of voluntary liquidation? From the commencement of voluntary liquidation till the receipt of the ultimate distribution, final distribution by the liquidator, what is the accounting by the respective stakeholders, respective shareholders? Do they still continue to show investment in shares at whatever values it's been outstanding in books, or the fact that voluntary liquidation has commenced? Because as the liquidator prepares its preliminary report, he gives an estimate of what he expects is the realizable value. And therefore, that should give the shareholders a good idea of how much are they actually expecting to recover from the shares. So I would say this becomes a fit case for testing the shares for impairment. Number one, disclosure in financial statements of the investor should come that the company is under voluntary liquidation now. So while it would still be showing as investment, but with a note that the company has now been put into voluntary liquidation process. And if basis the preliminary report, the shareholders find that the value on distribution will be much lesser than the value showing in books of the company, they should seriously consider an impairment also, because this becomes an impairment trigger. It becomes a trigger for impairing the value. So that is how I would see the accounting by the shareholders. And whenever interim distributions are made, they'll be knocked off, they'll be deducted from the value of investment. So the excess over the carrying value of investment will go as income. When my colleague Barsha was saying that can the liquidator declare dividends, and she said, no, we cannot, we don't declare dividends as is done by companies under, live companies. But any distribution by the liquidator is technically called interim distribution, it's called dividend. The word is dividend, meaning dividing the money, dividing the surplus among shareholders is called dividend. So it's technically called dividend only, but from point of view of accounting and tax treatment, the amount will be taken as dividend only when it exceeds the par value of the value of the investment. From tax point of view, section 222C comes to the extent of accumulated profits of the company, and from accounting point of view, as the distributions exceed the carrying value of the investment, the excess may be taken as either dividend or capital gain, depending on how would you want to see it. Mr. Shankar Panikar was saying something, but they would be okay. I think there was.
No, I just have small points. Thank you. I hope you remember me. Yeah.
Yes, sir.
I was just thinking 252.3 and the impact of director responsibility, because voluntary liquidation triggers based on a director, declaration of solvency, and assuming the company comes up with saying that okay, this cannot be dissolved, this should be revived, 252. Basically, it has to be. I don't think there is any case, after going through a voluntary liquidation, based on a declaration of solvency, then again coming with a, 252 talks about member, creditor, or workman. So basically, the question of the validity of declaration of solvency and, will be challenged according to me, because the honorable tribunal will ask n number of questions before giving life to a company which is already struck off by this thing. So therefore, I've not come across a situation where a voluntary liquidate company would be asked for a revival under section 252, for the simple reason that there's a high chance of fraudulent activity or something like oversight cannot be a reason for reviving. There should be some solid reason or ignorance from the part of the company directors, because declaration solvency is not a simple document. It's not just a minutes. It's actually end result of big time research, or I wouldn't use the word, lot of responsibilities cast on the directors to, give that declaration of solvency. So 252.3 after a voluntary, I fully agree with other aspects. I don't know, at least I have not seen a case where voluntary liquidation under 2013 Companies Act have come up for 252.3. So other gentleman was asking, could be right, but then member, creditor, or workman. 252.3 talks about member, creditor, or workman. So these three categories can only trigger for 252.3.
Let me just briefly comment on that. First of all, as I was mentioning, mostly revivals are done not because we find some unsettled liability. Mostly revival is done because we find some unclaimed assets. It's mostly done to claim some assets which were not known initially, but which become known later. Now, you would probably be wondering what could be assets of the company which are not showing on the balance sheet. Whatever is on the balance sheet, the liquidator will anyway claim and liquidate those. So like I was given an example, I think we also dealt with one such case some good 15 years back, and Calcutta High Court has plenty of such examples. And I can assure you that there are plenty of such cases of revival. You can see Calcutta High Court orders on revival. There will be many. So this case was one where there was a lease of a substantial godown space by Calcutta Port Trust. Calcutta Port Trust huge sprawling premises on the bank of the river Hooghly, and there was a major leasehold right in favor of the company. Because it was leasehold right, it was not capitalized on the books of the company. It was only in paying rentals monthly, nominal rentals, and had not capitalized. And the company went for liquidation. Everything was settled off. Later on, the promoters realized that they have a huge entitlement to a go down space. They wanted to claim tenancy against Calcutta Port Trust, and Calcutta Port Trust would argue that the company is no more there, so there's no question of honoring your right. So that's the company went for revival. And this point was made to the court that there is a valuable right which was not known, and therefore the company was dissolved without realizing the asset. The asset should still be realized and should be available for the stakeholders. The court ordered revival of the company. Revivals it's not something which is like happening on a routine basis.
No,
Exceptional circumstances, surely, but yes, revivals have been done by the courts in many, many cases.
Yes.
50, 60 years of winding up, there have been all kinds of non-recurring cases before courts.
Yeah, amazing presentation, sir. I mean, it was seamless
Thank you.
presentation. Thank you so much.
Thank you very much. Thanks, Atan.
Yeah.
Others, if you have any questions at all, or else I'll maybe pass over the proceedings to Prashla, madam.
Sir, I'm already done with my PPT, so I have given my deliberation. Now, if at all there is any question, I would love to answer those questions.
I would request all the participants to please put up their questions if there are any, so that sir and ma'am can address it.
So, Prashla, it seems that people are tired of roughly 4 hours, 3.5 hours of, non-stop presentation. So maybe time to give them some relief.
And please share the presentation, sir. It was very good.
Yes, sir. We would be most happy to pass it over to ICSI and they can
Sir, I have received the presentation. I'll share with all the participants.
Excellent. Thank you all. Thanks a ton for everyone. Thanks, Prashla, for giving us this time.
Thank you. On behalf of ICSI IIP, I would like to extend my gratitude to sir and ma'am for this excellent presentation and sharing your experience and expertise in the subject. Thank you for gracing our first event. I hope the participants have also contributed to this event. And thank you so much, sir. And thank you so much, ma'am. We look forward to your further contribution in our coming future. Thank you so much. And thank you all the participants.
Thanks,
Thank you,
I look forward to that.
participants.
Sure.
Thank you.
Thanks, everyone.
Thank you, sir.